York County Zoning Board of Appeals meeting is now called to order. So our first item on the agenda is the adoption of minutes.
I move to approve.
Second.
All in favor, raise your right hand. Okay, all right. Unanimous. Approved, thank you. So as we begin our new business, we will have an order of the cases. I would ask that everybody, turn your phones off or on vibrate. And when we are someone's talking to the board, please come up to the front to the microphone and speak clearly, introduce your name and your address. As we introduce these cases, the staff will give a presentation, followed by the applicant. And then we will open it up for public hearing, for the public to come speak for or against it. At the end of the public hearing, if there is no other additional information needed from the applicant or the staff, close the public hearing and make a motion to approve, deny, or delay any of the cases. So with that said, we have our first case. Something wrong with the slides? Bear with us while we fix the technical issues. Okay, there it is. All right. All right, so let's go ahead and our first case is number Z21-11.
Good evening. My name is Jeff Kirshner. I'm a planner for York County. I am filling in for Marion Ray on these next two variance requests. They're both road frontage requests. The first one is, switch over to here, is a variance of the road frontage variance request by William Joseph and Deborah Clinton. The property location is 3291 and 3287 Mount Holly Road. The zoning district is rural development, which is RUD. And the variance request from zoning code section 155.428C, which is minimum lot width / road frontage. The applicant is requesting have 0 road frontage for a new proposed 1 acre lot. You can see here the zoning district, the zoning map, and the location off of Mount Holly Road. This is the aerial. It's kind of hard to see here, but there's actually 2 structures on the property, 2 address structures, a single family home, and there's also a single wide trailer apparently is in disrepair, and the applicant is wishing to replace that manufactured home with a double wide manufactured home. But this being RUD, it's only 1 structure, single family structure per lot. So the applicant is requesting, this is the proposed survey, to break out a 1 acre lot that will have no road frontage, and that's what the variance request is for. And therefore, with as another single family lot, they could build another home on it. In this case, I guess another manufactured home. This project does not qualify for family exemption due to the lack of the minimum of 10 acres, as we talked about before. There are certain requirements to be a family exemption. They were modified a couple years ago, and this is only a 6 acre tract. And of course, they're proposing to subdivide out 1 acre. A new thing that staff is going to, we've always brought up the variance findings that the board has to go through in order to prove a variance, but staff is going to kind of give our interpretation of each project and each finding and make a recommendation based on the criteria, if it meets the criteria or doesn't meet the criteria. For number one, there are extraordinary and exceptional conditions pertaining to the particular piece of property. The existing lot only has approximately 25 feet of road frontage. It's already sort of a non-conforming lot. Because it's already non-conforming, staff believes that it qualifies for this condition because it already has a lack of road frontage. The minimum road frontage on this road would be 150 feet. So it would be a variance of 150 feet because the proposed lot is proposing for 0 road frontage. The B in the variance approval criteria is these conditions do not generally apply to other property in the vicinity. Staff looked around the area. There are other parcels that have 2 lots, even though this is RUD. There are other parcels that do not have the minimum road frontage. So it's not a completely unique property. There's other properties surrounding it that have similar conditions. So staff does not believe this meets this criteria. Number 3 or C, because these conditions, the application of this chapter to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. There are already existing home on the property. There's also existing single-wide home. The applicant actually could, the property owners could replace a single-wide with another single-wide, but the applicant wants to subdivide this lot and put a double-wide there. So the property is already being utilized. It already has homes on it. So staff doesn't believe that this criteria has been met. And the final one is the authorization of the variance will not be a substantial detriment to the adjacent property or to the public good, and the character of the district will not be harmed by granting the variance. There's already a home there. It would be a replacement of the home. It's not a major change to the property. So staff does believe that this finding does meet the criteria. Because it doesn't meet all 4 criteria in staff's opinion, staff is going to recommend the non-approval of the variance request. Of course, it's up to the board to make your decision what you find after the applicant has spoken. If you agree that they qualify for all 4 of the variance criteria. You have any further questions?
Yeah, I have a question. So they can replace the single wide with another single wide, but not a double wide, correct?
Right.
Because of the grandfathering. What is the reasoning behind, is it the size that
Yes, because having the 2 homes on the property, the 2 addresses, that's non-conforming.
Correct.
So you can't increase the non-conformity, but you
Gotcha.
can repair or replace.
Okay.
And so that's been staff's position that you can replace like, but of course, if you go with something larger,
right?
it's not exactly the same. It's not really replacing what has been damaged or needs to be replaced because it's in poor condition.
Okay, thank you.
Well, how long has the existing single wide been there?
And maybe the applicant speak to it. I know that it's been there for a good while, just looking at the aerials, but I don't have a specific date on how long.
Well,
it's
again,
been
was
there.
it prior to the 10-acre rule? And I saw in 1986, they've owned the property since then, which that was prior to zoning, which went into effect in the county in 87, period, to start with. So my question is, was it already cut up this way
Yeah, there was.
prior to the 10-acre rule?
Yeah, I believe there was a recombination that kind of, as stated in the staff report, that that kind of made it the shape that it is in now. Chris, can you go back to the overall? Yeah, as I understand, well, this doesn't work that way. As I understand, this shape comes from another subdivision, but maybe the applicant can speak to how long the manufactured single wide's been there, but it might have been there, you know, if you say previous is maybe the zoning, that's why there's 2 homes on the property. But right now, with the current zoning, it is not conforming to have the 2 single-family structures on the RUD property.
But it obviously was at the time they put this on.
I don't know if it was put on.
Well, they wouldn't have got a permit, occupancy permit if it
Right.
wasn't. Okay.
So it's just about the replacement and then subdividing out the lot interior and not having the road frontage is what
So all they're really doing is replacing the single wide with a double wide, and that's it?
That's what they're proposing, yes.
Okay, okay.
Any further questions for staff?
But along with replacing the single wide with the double wide, they want to subdivide that acre as
We
well.
want to have a 1 acre
Right.
lot, as shown on the plat. And I think that might have to do with, the applicant speak to that, but I think it has to do with financing. So will be, what they're proposing is a 1 acre lot that won't have any road frontage. It would only be accessible through the existing parcel.
So if we allow the double wide, which would allow them to have the 1 acre lot, it would still be non-conforming, but it would be one house per property, so that would be in conformity.
That would be conforming.
Yes,
Yes,
Yeah.
if this was subdivided into another lot.
right,
Then it could build, it doesn't have to be double wide. Any allowable single-family structure could go on that 1 acre lot.
Correct.
But that lot would not have any road frontage. and
correct.
why
That's the
it's road
non-conformity,
frontage
right,
variance.
okay.
Could they have made a variance request to put in a double wide versus a single wide? Or was their only option from a county standpoint, a variance for adding that lot?
I mean, maybe some other staff can help, but I believe that would be sort of a use variance, because they having the two structures there, it's not a measurement, it's not a setback variance or a road frontage variance. It's literally adding another structure to the lot and replacing it, not pairing it, or even replace it like for like. So it would not be allowed. It's not really something we can vary. We can vary measurements and things like that, but not the use of the property allowing two structures. In order to build a new structure on the property, it needs to be on a single family lot of its own.
Okay. Thank you. The applicant come forward, please. Name and address, please.
Yes, sir. Joshua Clinton,
Speak a little closer to the mic.
William Joshua Clinton, and 3291 Mount Holly Road, Edgemore, South Carolina.
Deborah Clinton, 3291 Mount Holly Road, Edgemore, South Carolina, 29712.
Would you just kind of explain again your rationale for the variance request?
Like the gentleman said, we're only replacing 78 model, was my grandma's old place. So, us getting older, we got grandchildren, we have kids staying with us, and it's a 2-bedroom, 1-bath. So we're just looking to get something, well, of course, newer, because it's starting to kind of fall apart. And just to get something bigger that we can have for our kids and grandkids to be able to be there as well. So, yeah, it's actually, the lot, the whole 6 acres is actually my mom's land. So what she's doing is just cutting us the acre out because they required us to put up the 1 acre lot as collateral on the mobile home. So, but we've used the same driveway for many, many years, as the variance. We both share the property.
In that survey plat, the easement that's shown, is that something that is new?
No, so that's been there since my mom and dad had built the house in 88.
So the easement going even to the 1 acre property was already there?
It has been, when my grandma came down there and lived on my mom's property. It was already down there, so it's been there.
Do you know how the mobile home is? What year?
It's a 78.
Answer your question there.
Yeah.
All right. Anybody else have any other questions? And basically, you say it does need to be replaced, and you want to replace it with a larger one.
And you said you are currently living in the single wide?
Yes, ma'am.
Okay.
I've been there for 5 years.
Okay.
So.
And the permit to construct the wastewater system, adding to the septic tank system?
We will be, yes, sir. We'll be
Okay.
doing that and, adding a well to our property.
Okay.
You did mention, I think you mentioned earlier, that parcel of land needs to be used as collateral for the new structure.
Correct.
Oh, so they're wanting it cut up, deeded, and shown as its own separate. Okay, all right.
No further questions? Thank you.
Thank you.
Is anyone here to speak on behalf of the applicant? Anybody here to speak against the application? Yes, please come forward.
Bonnie Clinton Dotson, 3287 Mount Holly Road. I am William Joshua's mom, and the mobile home that they live in now did belong to my mom. And when she passed away, he moved into it after his first divorce. And so he has remarried, and so he's wanting to get his son to come live, but he has to have a place for him to stay. And so they told me that they had to have an acre to go with their lot, as collateral for their mobile home. And the driveway that we've been using for many, many, many years is the drive that we all have been using, you know. And so I don't know if there would be a problem with them just continuing to use that lot, the driveway that we have now. Thank you.
Thank you. Anyone else want to speak for or against the application? Seeing none, the public hearing for this case is closed. Do we have a motion from the board?
I'll make a motion to approve it, the variance.
1 second.
We have a motion to approve and a second. Discussion.
It's an improvement. The driveway's the same. That's just the purpose of setback, frontage is too many driveways entering the road that's already there. That's in purpose, and, it's family. It's all family, and they owned it prior to the rules. So I do think they meet a couple of the hardships looking at the shape of the property.
Yes.
That's my logic.
And I think as far as, conditions that do not generally apply to other properties, we could kind of argue that point, but I think it is an unusual lot, and that kind of restricts that use there. The overall use is not really going to change.
Right. Taxes gonna go up.
Would not be a detriment to the surrounding properties.
Right.
I have nothing
Any
to
other
add.
questions? Any other comments? All right. Motion made to approve. All in favor, raise your right hand.
I just had one thing, I'm sorry, Rachel Grothy. I'm wondering if maybe y'all should consider as a condition of approval, I'm not sure on the actual legal status of the easement. So maybe including some language that when they submit for their map, that there is language included for that, and then that be recorded. Just a thought.
So I would say we need to amend the motion to include that when they submit the final plat for the subdivision of that lot, that it includes the shared access easement.
I'm okay with that amendment.
Yeah, second.
Okay. Motion to approve with the condition of the easement being on the plat. Okay. All in favor, raise your right hand. Okay. All right, thank you. Our next case, Z 21-12, Jimmy Ward.
Okay, we have another similar variance request. Applicant is Jimmy Ward. The property owner is Brenda Ward. It's just a planned property we're looking at. The property location is 220 Ward Drive, Rock Hill. The zoning district is urban development. Urban development actually doesn't allow single family anymore. That will be relevant. The variance request again is from section 155.428C, which is minimum lot width and road frontage. This is the zoning map. You'll see that it's zone UD. There's also multiple single-family homes off of Ward Drive, which is like a private driveway, but it's named. And this is the aerial. You kind of see the homes and the addresses in Ward Drive. There's a business owned by the applicant's house moving business, which is in the front on Neely Road there. That's what's up front. So there's kind of commercial in front, and then some family homes off of Ward Drive in the back is what you're seeing there. This is a 1987 survey showing sort of the original property. It's been zone UD in the past. I believe UD allowed single family, so it's been UD for a long time. This is a proposed plan. You see here the Ward Drive, and they're proposing a 1 acre subdivision of existing house. So this, I believe, is this Ward house, all existing, but it's all part of the overall lot that you see, overall parcel. And they want to subdivide out that parcel like the similar ones for the other houses were done in the past under family exemption. So you see a proposed new lot. It has access off of Ward Drive, but it doesn't have actual road frontage on Neely Road. So again, it's another zero road frontage request for a new parcel. In this case, the reason why it doesn't qualify for family exemption, even though they've owned it, it's already been, I believe, subdivided out 4 times previously in family exemption. There's 3. It's also in UD, so single family homes are no longer allowed use. So this is existing non-conforming. In fact, the houses are on the UD district.
I stop right there just a second. All right, now, it was UD zoned. You changed the definition of UD, or did you change the zoning?
The zoning district has been UD. It no longer allows single family homes. I believe in the past that it did allow some.
Yeah.
But it's non-conforming now.
But it was conforming when it was UD originally, correct?
Yeah,
Because that's a down zoning is what it sounds like you're about to do.
I believe this house was actually probably the original house before on the property, and the applicant can speak to the age of the house, but this might be the original house. It might even predate the zoning. But it is non-conforming in UD now as a single family. It's one of the reasons we have upcoming the condition requesting a minimum of 1 acre lot size, because single family homes aren't allowed in UD, so there's not a specific lot size for single family home. So we felt that was a prudent condition. If you do approve the variance, to make that a condition that it has a 1 acre lot size, which is what they're proposing for the lot. But it
You
is
still didn't answer my question. My question was, it was zoned UD that allowed it. You changed the definition of UD, or you changed their zoning? Which did you do? What
I
did the
don't know
county
exactly
do?
when UD was changed not to allow any residential.
Well, you said earlier that it was allowed, and then they're not allowed anymore in UD.
It's not, single family homes are no longer allowed in UD.
At the time this property was zoned, what was it?
I believe it was allowed in the past.
It was
I
allowed.
don't know the
Okay.
actual timing of when that was changed. Since I've been here, it's not been allowed. But as I understand it, there are multiple single family homes in our jurisdiction that are in UD. And they are non-conforming now.
But I ain't worried about the other one, just this one, this case. So basically, I guess, Michael, I want a little legal read on that. if you change the definition of zoning, but you don't give them the option to change the zoning, that's sort of a down zoning, isn't it?
One moment, sir. Ms. Dover.
And I guess I'm still trying to understand specifically what the question is. So if the single-family homes were allowed here previously, we would have gone through the process where they send the notice out to everyone that they're doing a rezoning, and at that point, folks can rezone, or they can come back.
Or did you just change the definition in UD? Which is, I think, what's happened here. Is, they didn't go through the rezoning process, because you didn't rezone it. You just changed what UD meant.
So I can add some clarity to this. Jonathan Buono, York County Planning Director.
Yeah.
So I don't have a specific date as to when this change occurred, but County Council voted to remove residential uses from the UD district, which is a purview that they have. All that does is that existing residential uses in the UD become legal nonconforming. They're allowed to continue in perpetuity as long as their nonconformity does not increase.
So with making this a subdivision for 1 acre parcel, that's increasing the nonconformity?
No, but the use itself is what's non-conforming, and they're not proposing in this application to add any additional homes. They are just proposing to subdivide it out, and it doesn't have any road frontage, which is what the variance application is for.
So we're only requesting to look at the road frontage.
That's right.
Okay.
Okay. Okay.
So I went back to the zoning map, just so you can see that there's other subdivided lots, again, I think the previous family exemption that was utilized to break out other single-family homes that are in the UD from the parent property, the original property. This being maybe the oldest house on the property, that is still part of the parent property. And then, no, it's sorry, this way, to the, now they're proposing to break it out as a 1 acre lot on its own. The house stays the same, it's still, there's already a house there, but it'll be a new lot from the family lot, the large UD lot. It would still be zone UD. It still would be non-conforming as far as being a house, but it would have its own parcel.
So in the package, it mentions about previous efforts to rezone to residential.
Yeah,
Was that
looked into
recently for this one or prior?
so because of the change with UD, because UD does no longer allows single-family homes, the county over periods of years, I'm not sure how long the project went on, offered residents, including residents in apparently this area, the opportunity to rezone to a residential district. It basically would mean your house was no longer non-conforming. It would help if you want to replace the house or do an addition, stuff like that. But so far, this property has not taken, didn't take advantage of that, didn't rezone it. Of course, there's a business on the front of the property, so that might be, the applicants can speak to that. For me, that's some of the reasoning, because they're trying, the UD is allowed for business, so they didn't want me to change that. So it's remained UD with the exception of the one lot you saw that was, I think, maybe RD1 rezoned several years ago, and that was to build a house on it. So I think the lot maybe was broken out for family exemption. They rezoned it so they could build a house because it's a residential lot that in the middle of that UD property owned by the wards.
Even if it was a residentially zoned property, it still wouldn't change the need for the variance for the
Yes,
frontage.
it still would not have road
Yeah,
frontage
I get
because
that.
Ward Road is
Yeah.
not a public road or a private road built to county standards, so it still would not have road frontage.
You know if that private right-of-way is platted currently?
It shows up on it shows up on the plats, but again, I don't know if we have our notes where we found an easement, like a recorded easement.
A recorded easement for it exists?
Well,
A recorded easement does exist?
I don't see one
you did not find
in
one.
the
Okay.
packet, so I'm not sure. I know it shows up on the plats, and of course it's named, but I don't know if I've seen an easement document, so we might have the same similar question from the last one to make sure if there's a recorded easement, not just showing up on the plats. So with the findings, we'll go through those. There are extraordinary and exceptional conditions pertaining to a particular piece of property. This property is unique. It has a mixture of residential and commercial. As we talked about, it's zone UD. Of course, it has an existing home on it, so there already is a home. The use is already established on the proposed parcel. So staff believes that this variance criteria has been met. Condition 2, or finding 2, these conditions do not generally apply to other properties in the vicinity.
Wait, can you go back to A? Because you're saying that it does not meet the criteria on mine.
No, I believe I meant, staff believes it meets the criteria. We believe it does meet the criteria.
Jeff, do you want to pull that
Oh,
up
it does meet,
on
okay.
the slide? I think the clicker
Okay,
works now.
sorry, you're right,
should
it does
be
meet.
on the podium.
Okay,
Yeah.
there we go.
Okay, no, you're
So
right.
we're, for A, staff believes.
I stand
looking at it
corrected,
does-
yep.
Yeah, okay.
I was looking at the wrong one.
Okay, and then we're looking at B, so these conditions do not generally apply to property in the vicinity. We looked around and there's other lots without road frontage. There are a couple lots with, multiple parcels on them. Because this is not a completely unique situation, it's in the sense of not having road frontage, at least as far as the road frontage goes, staff doesn't believe it meets this criteria. Number C, because of these conditions, the applicant of this chapter, the application of this chapter to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. The house already exists. You know, it could be moved into, it's already been lived in, but it could be taken, it could be willed. Actually, this could be done by will as far as separating out the 1 acre at a later date. And because that's a court order, is exempt, so we'd have to approve the plat, exempt the plat. So because the property's already being utilized, the house, it won't change the fact that sorry. That the house, lose my voice. Sorry.
You want a drink of water or something?
Need a drink of water.
Please. I was like that today talking on the telephone, and just didn't want sound just did not want to come out.
It's that yellow stuff.
I was getting over a little kind of allergy and cough stuff, and just kind of came back. Thank you for the water, for letting me get the water. Because it's already a house and it's still can be utilized as a house and different family members can move into it, we don't feel that the variance is absolutely necessary to utilize the property. The authorization of the variance, the number or letter D, the authorization of the variance will not substantially detrimental to the adjacent property or to the public good, to the character of the district, will not be harmed by the granting of the variance. Because it's already existing condition, you already have the single-family lots, you know, on the UD property. We do think, we don't really see where there's a negative impact to the neighborhood, because obviously nothing's changing except for the lot lines. Again, if you do decide to grant the variance, staff does recommend one condition, that the new lot be at least 1 acre in size. That's again because in the UD district, we have a minimum lot size for single family, so that gives some guidance there. And it brought up the possibility of maybe a second condition, as we talked about, could be to make sure that Ward Drive is an easement that is granted and will grant access to these properties in perpetuity. Just make sure on that before the plat's recorded.
Okay. Any questions for staff? Thank you, Jeff. Mr. Ward, are you in? Please come forward.
Jimmy Ward, 228 Ward Drive, which is adjacent to this property. My mother actually owns it. The reason we're doing this is because she wants to get it changed before something happens to her. She's got some age on her, so she's giving that house and property to my youngest son. He just got out of the Navy and he wanted a place to live. So we've had it surveyed, we got the easements took care of. Was gonna rezone, and we found out we didn't need a rezone, all we needed was a variance to get the patches taken care of. So we started the rezoning process, we canceled it. It took a while, how we figured that one out, y'all helped us figure that out. So all we're doing is, it's just a legality. I mean, if she passed away, they could do it anyway, but she wants to see it done before she passes away. And, the other house you were talking about actually was moved, we don't build them, we move them, so that was a moved house in that was put on another piece of property. But that's the reason we're doing this, only because she wants it in his name, where she can see this happen before anything happens to her. And that's the only reason we do it.
Have you thought about rezoning?
We did, I talked to them, and it was just a process, it was something they recommended we go this direction with, because even though it'd be commercial in his name, the UD, whatever, it's just a little bit higher taxes, he got it all free anyway, so we didn't see the difference in the,
What's the relationship with the business?
It really don't. When my father lived, he lived there, and actually that's what started the whole business out there. We got our front part of the property, his business, and if we'd had to rezone, we was going to have to cut some of that off. And my brother and my sister, we weren't willing to give up any of the commercial property on the front to my son because we need to keep the business the way it is. That's the reason we just had that 1 acre surveyed out. A little over an acre is on y'all got plats on all that, okay, turned in. And that's the only reason, like I said, we changed it.
And is the easement, did you file that with a plat, register of deeds?
All those plats, I had the surveyor do all that because I knew we had that same situation with my daughter's house. That my mother gave her the piece of property on the other side when we moved her house in. So all that should still be on that. It's an asphalt road in there. Of course, it don't meet none of the standards, but it's our road, which all family lives there. And that's, till I die, that's all it's gonna be there. But I mean, anything can change over years.
Any further questions for Mr. Ward? No? Thank you. Is anyone here to speak in favor of the application? Anyone here to speak against the application? Seeing none, public hearing is closed. So, just have a motion?
I'll move to approve, so we get the conversation going.
Second?
Did you want to add those conditions
The acre
as
lot?
part of the approval?
Oh, we do
Oh,
it.
if you're gonna approve it, you want those two conditions?
Oh, yeah, yes, I do.
Okay.
I'm sorry, I need to tell, you talking about the,
1 acre minimum lot size.
minimum
1
lot
acre
size
minimum.
and the platted,
Easement.
Right.
But he says he's got a survey done on it, so yeah. So I move to approve based on those two conditions, 1 acre lot size and a platted, easement. in the property.
Second?
Okay. One thing that hit me funny on this though, once again, is it's one of these pieces of property that the definition of the zoning got changed rather than the zoning being changed. Because UD at one time would allow a trailer park. Then the county council came in, I don't know why they did that, why they didn't do a UD1, a UD2, as they did modifications to the zoning, so you'd have a history of what it was. So, because I'll be honest with you, when I first looked at this, I'm like, you're in the wrong place. You need to be getting this property rezoned. You know what I mean? And then you wouldn't have an issue there. That's the first thing. That's what my question was about earlier. Because I've seen that done before. I had it done to me one time too. And by changing, I wish they wouldn't do it that way. But that was just my opinion. I don't see what else they can do.
Well, I have a hard time with, under the criteria that we have to go by is number C, because basically a variance isn't necessary. Basically, the house is currently conforming, and by subdividing it, would it increase the nonconformity. So the grandmother can pass it down through a will, but she obviously doesn't wish to do, but, I mean, that is a way of keeping the house in conformity. And I think as a board, we have to do our best in following the variances and the ordinances. So that's where I'm kind of stuck.
That was my point, Barbara, in that it would have been okay had they not changed the definition of UD.
Correct, I understand that, yeah.
That's why I brought up what I brought up. Then he would be the acceptable use, and that would meet the criteria.
It would still be a non-conforming lot. I mean, basically,
Yeah.
you're creating a non-conforming lot.
Which has to
Yeah.
abide by the
But
road
there's
frontage.
also already several non-conforming lots
In there,
along Ward Road.
and there's not, and they don't have any frontage to take it from. Doesn't look like me.
No.
So I don't have any choice.
No, to make those lots conforming, they'd have to petition the county to take over that road and bring it up to standards, which
Can't.
unreasonable.
That's right. Well, they'd have to pave it to standards.
I guess for number C, I'm not sure how you could, giving it or willing it or to the grandson or son would, it could be considered unreasonably restriction depending on, I guess, ownership type situation. If the ownership is, I guess, desired and not just living there.
I mean, you could say it was unreasonable because if she wanted to sell her house, she couldn't without selling all 52 acres or whatever it is.
Exactly.
I mean,
Yeah.
that would certainly be the definition of unreasonable.
That's unreasonable, that's right.
Good point.
Yeah. I do.
Any further comments? Questions? No? All right, so we have a motion to approve with the conditions of 1 acre size lot and make sure that the easement is legal and with the filed with the Register of Deeds. Okay. All in favor of the motion, raise your right hand. All not approving? Thank you.
Deny?
All right, denied. 4-1. Yes, 4-1. Thank you. All right, our next case, Z21-13.
Good evening, Rachel Brophy, zoning administrator for the County of York. So this is our administrative appeal. So it is an appeal to a determination regarding the utilization of an access easement for parking spaces required for a proposed hotel. This is for a property at 1842 Coltharp Road in Fort Mill. So the applicant requested a formal zoning determination regarding the utilization of an access easement for parking spaces required for a proposed hotel use. Staff reviewed the submitted sketch plan and easement agreement document and determined that the utilization of the access easement for required parking is not allowed. So the property is an approximately 2.36 acre vacant lot, and it is located on the corner of Coltharp and Pleasant Roads. The lot is zoned business development 3. Here's the zoning map. And then here's an aerial just sort of giving y'all a little bit of a better idea. The site is adjacent to an existing hotel, Home to Suites, and an almost 5-acre vacant parcel, which is owned by the grocer Lidl. So some background information. So in October of 2020, a sketch plan was submitted to our department for a 4-story, 100-room hotel. Plans showed the required parking within the access easement. Staff provided comments, and one such comment was that parking would not be allowed within the easement. As such, the applicant requested a formal determination in January of this year, 2021. And so now here we are. The applicant is appealing staff's determination to disallow parking within the easement area. So some site history. So in early 2016, Lidl submitted a commercial site plan for staff review to develop a 35,000 square foot grocery store on an approximately 5-acre parcel located at 1840 Pleasant Road. So this is known as the Lidl parcel. So the Lidl parcel directly abuts the subject parcel and 1840 Colthorpe, which is a 2.5-acre parcel, and that contains a 110-room hotel, and that is the Home to Suite site. So the Home to Suite site project received site plan approval in January of 2019, and it's currently open and operating. Part of the Lidl project included the closure of Isom Road, which was a public road, and that provided access from Pleasant to Colthorpe and all of the other parcels. So as a result of this closure, the Lidl project was conditioned to provide access via a shared access easement for the other 2 parcels. The 50-foot wide protected drive was to be constructed from Pleasant Road and traversing all 3 subject parcels, with access provided to Colthorpe Road. Approximately half of this protected drive has been constructed, and it was a part of the Home to Suite project, with the drive connecting at Colthorpe, and it stubs out at the property line shared between the Home to Suite site and Lidl. Currently, the only way to access the Home to Suite site is from Colthorpe Road. So once Lidl begins development of their site, they will be required to construct the remainder of the protected drive from the current stub out over to Pleasant Road, which will thereby create continuous and unobstructed circulation and access between all 3 parcels and the 2 roads.
Okay, here we go.
So this is the sketch plan that the applicant submitted for the proposed hotel. So the proposed hotel site is shown in purple, and the Lidl and Home to Suite sites are shown in blue, and then the red outlines the existing access easement with parking shown within the easement area. And then this is a copy of the approved site plan for the Lidl site. So this was just to sort of provide y'all with a more sort of complete picture of what that access road is going to look like on the other side. All the colors are the same. Lidl and Home to Suite site in blue, access easement in red, and the proposed hotel down in the lower left-hand corner.
So going back to that picture, the Lidl site has access, right, off of Pleasant Road, and the Home to Suite site has it off of Colthorpe?
That's correct.
And then the proposed hotel site does not have access separately from those? Would not have access
Their access would be, you can see it right there.
from Colthorpe?
Yes, that's correct.
Okay.
And I don't know I don't think there is access then for the Lidl site because that hasn't been constructed. But theoretically, it will have access once it is constructed off of Pleasant.
But Lidl's site plan has been approved, correct?
That's correct.
Yeah.
Go back to the previous slide again, please. Okay, so with the hotel there, they couldn't have access from Colthorpe other than the shown access easement. Okay.
That's correct. All right, so staff's analysis. So per the agreement, an easement is required to be 50 feet in width. Any parking within the easement diminishes the free and open access easement to a lesser width of 24 feet. And then further, for South Carolina Code of Laws, the local planning agency, which is us, must not issue the permit unless the local planning agency receives confirmation from the applicant that the restrictive covenant has been released from the appropriate authority or property holders. So to date, staff has not received communication from all parties to the agreement regarding the proposed modifications to the access easement. So, and sort of wrapping up my presentation here. So in terms of the role of the board tonight, so you can uphold the administrative decision entirely. You can change it as you see fit, or you can overturn it. So this concludes my presentation. I'm available to answer any questions that y'all may have. And the applicant is here as well.
Okay. Any questions for Rachel?
So is it correct in my understanding that the reason the applicant desires to put parking in the easement is because in order to be approved with the site plan, they have to have so many parking, and that's where they need to park? I mean, they don't have enough parking in the...
That's correct.
Okay.
It is required parking. I believe it's
How many?
Proposing a 100-room hotel. They have, I believe, 100 spaces shown on the plan, which I think makes them a couple or a few short because that doesn't account for any sort of office space for staff.
Okay.
Any further questions?
So the only other way for them to get those spaces is to basically put them in that easement designated area that they need an agreement for all parties to do so, but you haven't received anything stating of such. So that's how I'm hearing that, correct?
That's correct.
Okay.
Do you know if there's any restrictions on having parking within the building footprint?
Within the building footprint?
Yes.
As in like...
So like first two levels?
Like underground type stuff or
Like
deck
maybe the-
structure type thing?
Yes.
No, there aren't any restrictions.
No further questions? Thank you. Would the applicant come forward?
Good evening, board members. My name is David Kimball. I'm with the law firm of Robinson, Bradshaw, and Henson in Rock Hill. My co-counsel is right there, socially distant from me. His name is Rip Sanders from Columbia, and his name's on the application, but I'll be presenting for the applicant this evening. Let me begin by just trying to clear the air a little bit, anticipating some comments that you may hear so that we focus on what's really at issue and can leave aside things that aren't at issue. This is not a petition for any sort of rezoning, variance, or any question about the use of the property. It is zoned BD3, a hotel, as an expressly permitted by right use. I just want to make that abundantly clear at the beginning, so we're not talking about that. What we are talking about is this one question: whether or not my client has the right as the property owner to park within a designated area on its own property. I want that to be abundantly clear. We're not talking about an easement on someone else's property. It's an easement that we granted to other people on our property. And that is the question, whether or not we have the right to park within that easement area. So with that as a baseline, if I may approach, I'd like to hand out some summary exhibits, which I think will help clarify this issue a little bit. There's some pictures, maps, that sort of thing.
Thank you.
Thank you.
So if I may, I'd like to just explain the context here a little bit. I have a few disagreements with the way that the zoning administrator presented this. Not many, but a couple ones that are important. So let me explain how I view this. What you're looking there on the first page is a, obviously, GIS map. The highlighted portion is the parcel that's at issue. That's my client's parcel. They paid $500,000 for that beginning of this year. They're the fee simple owner of the project. This is not some contingent sale. They own it. They've invested real dollars.
Sorry, when was that purchased?
It was in this year. Correct, February. Next door to the east is the Home 2 Suites parcel, which the zoning administrator alluded to. And then below that to the south is the Lidl or Lidl parcel. I'm not from Sweden, so I'm gonna say Lidl, if that's okay with y'all. What you have here is outlined in red. That also comes from the GIS map. That is the existing hotel, which is adjacent to the subject parcel. The Home 2 Suites parcel has an operating hotel on it, about the same size of the hotel that we're proposing. So for context, back in 2017, an easement agreement was entered into between my client, or the predecessor of my client, the developer, and Lidl. And what that agreement said is Lidl could have an access easement. It gave effectively secondary access to Lidl. They have their primary access from Pleasant Road, where they'll be granted at least one curb cut there to access their parcel. But they wanted kind of a back door. So not primary access, but secondary access to their parcel. Specifically, what the easement agreement provided was a 50-foot wide access easement. It says that, 50 feet wide. But, and this is a key distinction between our understanding of the agreement and the zoning administrator's understanding of the agreement, the entire 50-foot easement is not to be used. There is a much smaller, it's called a protected road within the confines of the easement agreement. 24 feet wide, we measured it today. It's a 24-foot wide protected road that is within the bounds of that 50-foot easement. And importantly, the developer, my client, has the right under the easement agreement to move that road anywhere they want to, anytime they want to, within the 50-foot bounds. So if, for example, they wanted to put parking on one side of it and there wasn't quite enough room, they could pay at their own cost to move the protected road enough to allow for parking. And that's important because it indicates that no one thinks that that 50-foot easement is entirely protected. To the contrary, there are 24 feet of it that are protected. The rest is unprotected and can be used for any number of uses.
Can you state, are you looking at, would be our attachment A, which is the Declaration of Restricted Covenants from 2017?
That is correct.
Okay, where specifically are you seeing this 24?
The best place to see that is if you, I think there are numbers at the bottom, yes, at the bottom of each of these pages where it says it's a deed book reference. If you look
Right.
at page 303,
303?
there's an actual sketch plan drawing of it.
We don't have, we don't have 303. Do you guys have 303? Are you talking about this number down here?
Yes, ma'am, I am.
Ours only goes up to 267, I believe.
I got 302 right here.
Oh, you have 302?
And 303 is,
the Kimley Horn.
Oh, that, I've got that. Yeah, that's separate. Okay.
And if you look, you can see very clearly on that page 303 that there is a 50-foot private access and utility easement. It says that, clearly marked. But within that is what's called a protective drive, 15 miles per hour. That drive clearly does not take up the entire 50 feet. And nor would it, because it's not expected to be a primary access drive. And importantly, this gets a little legal, and I apologize for that. Within the grant of use of the easement agreement, it specifically says, if you flip back a few pages, that owner agrees Page 265, if we're navigating by those same numbers.
Yeah.
Owner agrees that without the prior written consent of the consenting owners, the roadway shown on the easement exhibit as protected drive, including without limitation, all curb cuts within such drive shall not be materially altered or relocated. Then that sentence goes on for a while.
Hold on, make sure everybody's looking at the same wording. Page 267.
265.
Under B, correct?
Yes, ma'am.
Okay. And how far down are you going?
I'm just, the second sentence is the
Okay.
critical sentence here. It says, notwithstanding the previous sentence,
Okay.
developer, and that would be my client, the predecessor of my client, developer or its successors or assigns may alter or relocate the protective drive, including any utilities located there, contained therein, at its sole cost and expense, and upon providing reasonable written notice to Lidle, obtaining necessary approvals for such alteration or relocation from the appropriate governmental authorities, and provided that such relocation does not interrupt business operations of the Lidle grocery store, et cetera, et cetera. So it's clear that within that 50-foot wide easement, which is not designed to be used in its entirety for a protected drive, my client has the right to move the road. And that's important because it means that there are spaces outside of that protected drive that can be used for other things, for example, parking. Now, there's another part of this agreement that's actually probably even more important than that provision. If you would flip back just one page, page 264. Section 3.1, for ease of reference, I actually included it as the last page of that packet I handed up, and I highlighted the language that I'm going to quote to you here. I'm going to turn there. This is the grant of access. Developer hereby grants and conveys to Lidle for the benefit of and as a pertinence to the Lidle parcel a 50-foot non-exclusive ingress and egress and utility easement over, across, and under what? The protected drive. That is the grant of access. It's over the protected drive, which, remember, is 24 feet, and it's shown on that exhibit. It's not the full 50 feet. That's point number one from that sentence. The next point is this. If you continue reading on, it says the access easement is being granted, this is the part that I've highlighted in your attachment there, is being granted for the benefit of the Lidle parcel for the purposes of vehicular and pedestrian access, but not parking. That's the phrase that has gotten us stuck. That's what's really hanging up the zoning administrator, I think. And I want to explain what that means, if you'll allow me. Just because my client restricted the neighbor's rights to park within the easement area does not mean that my client has restricted its own right to park within the easement area. Think of it this way. If I have a pond and my neighbor wants to fish in my pond, and I say, you can fish in my pond from sunup till sundown, but you can't fish at night. That restricts my neighbor's rights of when they can fish in my pond, but it does nothing to affect my rights as to when and where and how I fish in my pond. It's the same thing here. The neighbor's rights are restricted. Our rights are not restricted to just parking, or excuse me, to exclude parking. I want to pause there just to make sure if you'll have any questions. I'm throwing a lot of this at you probably for the first time you're really diving into this. Okay. Moving ahead.
And this has nothing to, this is totally separate from the 2018 agreement?
This is from, it's actually 2017. I'm going to get to 2018. What happened was, in 2017, Lidle and the developer parcel entered into this easement agreement. In 2018, Home 2 Suites came along next door and they said, hey, we want the same thing. And so all we did was basically add them in 2018 to the same agreement, gave them the same limited rights of use. We said they can use this protected drive for, ingress, egress, vehicular, pedestrian traffic, but not parking. It's the exact same language. So the intent from day one was to restrict Home 2's ability to park in this easement and Lidl's ability to park within this easement, but not my client's ability to park within this easement. Client would never have agreed to that. So, in October 2020, as the zoning administrator said, a proposed sketch plan was submitted. That sketch plan, and again in the packet that I handed up, is the second page, just for ease of reference. I wanted to have y'all have all this stuff ready. What you can see within that proposed sketch plan is the protected drive. The easement, the full 50-foot easement, is the dotted line. That is correct. But again, within those 50 feet is a 24-foot preserved, free, unrestricted, clear access for vehicular and pedestrian traffic, just like we agreed. On either side of that drive aisle are parking spaces. Again, consistent with the parties' understanding of this easement agreement that we could use the areas outside the protected drive for parking. This is not unusual. This doesn't restrict anyone's access. In fact, I noted when the Vital site plan was up there, it looked like they have some similar arrangements in their site plan. And just to be sure, we went out and took pictures of the next door neighbor, the hotel. And if you want to look at your packet that I handed up, there's very good pictures. If you look at page 8 in particular, you can see very clearly they have parking adjacent to a drive aisle. And in fact, it just so happened when the picture was taken, a FedEx truck was using that drive aisle, parked, got out, delivered its packages, and left. There was no accident, there was no hullabaloo, everything went off without a hitch. So in October 2020, when we submitted the sketch plan, it was denied by the zoning staff and administrator in a letter dated January 25th, 2021. And the stated reason for that denial was that the easement agreement doesn't allow it. And that's the statute that was referenced. That we needed to go get the consent of our neighbors to allow this access. We don't have to do that because we already have that right of access. We already have the right to park there because it was preserved in the original easement agreement. So that was the basis for the denial of the sketch plan. And respectfully, we think they got it wrong for 3 reasons. The first reason is this. Under the law, statutory law and local ordinances, the zoning administrator and the zoning staff are prevented from interpreting private agreements between private parties for purposes of determining certain land use restrictions. Specifically, South Carolina Code Section 629-1145 says it does. This is the statutory section that was quoted in the denial letter. If it's read in full, it says, it does not apply to requests for, quote, authorization to build or place a structure on a tract or parcel of land. That's what this is. It's a request to place a building or structure on a tract or parcel of land. They're not allowed to wade into private agreements in those situations. Secondly, the zoning ordinances of York County provide that the zoning administrator's authority is limited to administering, quote, administering the zoning ordinance and enforcing the regulations imposed by the ordinance, end quote. It further states in section 155.004G that enforcing protective covenants and deed restrictions is beyond the scope of the zoning administrator's authority because these agreements are primarily private agreements between private individuals and the government doesn't have really a role except in the court system. And if a private individual wanted to sue us over this easement agreement, that's where we would go. The courts interpret private agreements between private parties. The zoning staff and zoning administrators do not. So our first point is simply this. They exceeded their authority by basing their entire decision on an interpretation of private agreements between private individuals. They lack the authority to do that. Point number 2 is this. Even if they did have that authority, they misinterpreted the agreement between the parties for the reasons I've already explained. They thought that the easement was this wide and it had to be completely unobstructed and clear. It didn't allow us to park there, but actually it does. They just misinterpreted the agreement, and we strongly disagree with their interpretation of it. That's the second point. Thirdly, and we have a representative here from our engineering firm that submitted the original sketch plan in case there are more technical type questions. This drive aisle, this 24-foot drive aisle with parking on either side, does not restrict access. The parking in no way impedes the flow of traffic. It just doesn't. Again, the next door neighbor hotel has similar types of drive aisles. Vital surely will have similar types of drive aisles. We haven't seen it yet, but we think they will. And so just as a purely factual matter, there is no impediment to ingress, egress, vehicular, or pedestrian traffic resulting from these parking spaces on either side of a clear driveway. So for these reasons, we would respectfully request that this board overturn the decision of the zoning staff and administrator to approve the sketch site plan as submitted. I'm happy to answer any questions you may have.
This picture, this image, if you look at it closely, it looks like this hotel has parking on your property. So maybe is this a little bit off?
Again, that's the county GIS website.
Okay.
I've noticed that the table things are not exactly precise.
This shows a little more clearly.
That's more clear, yes, sir.
Address you got a letter in the package that the staff gave us that from Lytle, or Little, or however you say it, that they're writing to say that they do not want you to put the parking spaces in there as well. Can you address that?
Certainly. To be completely clear, I'm not sure where that letter came from. It's not signed by anyone. It was included in the packet. I take it was submitted through some channels to the board. With respect to Lytle, I don't have any beef with them. They don't have the right to object. They've already agreed to allow us to park there. So I respect they may not want it. They've already signed on the dotted line.
Okay.
On page, this is the addendum to the administrative appeal from Solera. On the second page, which is page 53 in the ZBA packet, the second full paragraph down, it talked about the property owner would never have agreed to restrict its ability to place parking within the easement area. In fact, the easement agreement expressly reserves to the property owner, referred to as the developer in the agreement, the right to alter or relocate the protective drive, including any utilities therein, at its sole cost and expense upon providing reasonable written notice to adjacent owners who are using the private access road. Is there such a letter that was written?
That's a reference to the easement agreement. That language being quoted there is a reference to the easement agreement, which we read earlier.
Okay. So there was no written notice to allow the owners to disagree or not?
There was not. And again, our position is they've already agreed to allow this in the easement agreement, so we don't need their further consent to this.
In any of the easement agreement documentation, is the word protected drive ever defined? I mean, that's,
Yeah,
that's an interesting
I have scoured it. It's not defined.
way to put it.
Absolutely right.
Protected, I've dealt with joint access agreements and this and that, but protected drive is somewhat a new term to me.
Agreed. I'll tell you my take on that. The idea is that 24 feet is, holy ground. It's safe. It's protected. It can't be, you've always got to preserve that 24 feet.
Protected from what? Development? I mean, that would be
From
somewhat
parking
obvious.
spaces, among other things. Sure, it could be anything. But I would say that outside of that protected drive, the implication is it's unprotected.
The 50-foot easement is not necessarily considered part of that protected drive in the agreement.
That's correct. In fact, I would go one step further to say it's expressly shown to be not part of that protected drive. The protected drive is not the full 50 feet of the easement, as you can see on page 303.
Looking at the reciprocal easement agreement, if we flip to page 7, which at the very bottom it says page 415, item 10, if you can answer this for me. It says Lytle grant of access easement for hotel partial. And in it, it says Lytle hereby grants and conveys to hotel developer and on and on and on and on. I won't read all of that. And then it goes down and it says about halfway, construction from time to time, a Lytle parcel arising from and after the date that Lytle store shall open to the public for the purpose of vehicular and pedestrian access, but not parking
Correct.
by the hotel developer. So now, I'm no attorney, which you are, but reading this, it sounds, I mean, am I wrong? And I mean, we're here to be educated if we are. It sounds as though this is something Lytle is agreeing to that puts limitations on what the hotel can use that for. So,
A couple of things. First
okay.
of all, the hotel parcel there is not our hotel, it's the neighbor's hotel. Remember, there are two hotels.
Right.
It's the Home 2 Suites. They are saying that within, and I'm gonna look at my real estate lawyer here for a second, make sure I got this right. Within the Lytle parcel, they're gonna be developing that at some point in the future, presumably. The hotel, the existing hotel, Home 2 Suites, can't use the Lytle parcel for their parking, for the hotel's parking. And that's not surprising.
Mhm.
You know, the Lytle doesn't want the hotel people parking in the Lytle parking lot.
Right,
The hotel doesn't
right.
want the Lytle people parking in its parking lot. But that does not pertain to this access easement that we have in place, the 50-foot that's then cut down to the 24-foot protected drive.
Right, if I may add, it's Rip Sanders. So this is Lytle's grant upon their property. So when they build out their parking field that has drive aisles, they're offering so that patrons or customers of the hotel developer name
Can have
access through there.
to go through but not park.
But they're not park, just like, and so that's just how they use that parenthetical by not parking in the grant from Lytle. They've done the same thing in our grant. I think it's illuminating that you brought that up because that is exactly, you know, if we follow the logic of the way that the zoning administrator is interpreting this, then that would mean that Lytle's saying they can't park on their property, right? Right, because they're granting, and then they're qualifying to the hotel developer neighbor. They're saying, I'm granting you access to my parking fields, but I'm qualifying this easement, you can't park there. That's the exact same thing that's going on in the grant in 3.1D, where my client grants to the other parcels their right to use the protected drive, but not park.
Okay, so for me, how that would really bring it home, at the time this agreement was executed, signed, etc., there was Lytle and the Home 2 Suites. But was there a third party with another parcel, and at the time, it was not deemed going to be a hotel at the time?
It was 4-star.
Okay,
The developer, our client.
Our developer, we stepped in the shoes as successors in Iowa, right?
okay,
So they would not, you know, they didn't have a contemplated use at that point, but certainly as property owners and actually developers in the business of buying and selling development properties, they didn't restrict, there's a whole other section for restrictions upon use.
okay,
And that's agreement between the private parties outside the zone, like a tattoo parlor.
okay,
It doesn't restrict us from a hotel, the parties agreed to that. A part of the amendment as well, because the amendment brought in the hotel developer, because originally the hotel developer parcel were two different people, they were residential owners. And they had a right to use it to access their residential property, but they couldn't have commercial traffic. So, and then legal was under the obligation in the contract, had the financial obligation to build the road. And so when the hotel developer came and said, I want to build by this amendment, I mean, I want to get in on this, I need to have commercial access. It's negotiated in this that obligation, that financial obligation to build the road passed to the hotel developer in exchange for him getting the right to use it more so than they had before for their own residential use. And Cockrell and Smith, those are the two predecessors in title to the hotel developer. Those whose shoes they step in. So when it says no parking by the property owners, it means the owner of that hotel parcel, not our hotel, not our client, not the owner fee of the underlying, because we're granting the easement.
Okay.
Further questions?
Right now, no.
Well, I would just reserve the right to respond. If there are any comments, I would ask for an opportunity.
Yes, please. Yes. All right, do we have any other individuals that would like to speak on behalf of the application? Please come forward. Seeing none, anybody to speak against the application, come forward.
Good evening. Michael Slavatinik, Senior Real Estate Manager for Lidl US. It's 1760 Pleasant Road. We are in agreement with the zoning administrator to deny this request. Granting the ability to park within this easement will restrict our truck route for the future, so we won't be able to actually deliver any groceries. So if they end up building the parking within this easement, it's going to restrict our ability to use the property. When we went through the site plan approval process, we had to do a traffic impact analysis, which allowed us, which is why we had to come back and build Coltharp Road. So our direct access from Coltharp Road as a truck access was required for our traffic impact analysis. So that's pretty much it.
So you don't have access off of Pleasant Road?
We have access off of Pleasant Road, but the way that the site plan is approved, our truck can only get into the property and into the loading dock area via the Coltharp Road access. So by having the parking there, it restricts our truck turn and our truck movement for our WB67, which is 67, foot tractor trailer, and the ability to deliver the goods to the stores, thus limiting our ability and our use of the property.
So if they provide, you're saying if they provided 24 foot. So I've heard a couple of different things. I've heard 24 foot from those folks, and then when staff was doing their presentation, I heard that having that parking in there would not allow it to have a 24 foot wide drive. So I've heard two different things. A 24 foot wide drive would allow access with the trucks, or would it not? You need something more.
Yeah, we need, I would have to circle back with my civil engineer just to confirm, but through consulting with them, everything that they've been shown based on the applicant's submitted sketch plan would restrict our ability to have a truck come in and out of the property.
How wide is that drive actually off of Colthorpe? Because I'm looking at the figure and it's got 50 feet, but the drive is less than 50 feet. Whether that's 40 or 30, I don't know, without taking a ruler to it. But even that looks restricted, so that'd be
Are you talking about the road,
off of Colthorpe.
right before you get to the easement?
Well, Colthorpe probably only has 24 foot of pavement.
Right, coming in on off of Colthorpe.
Right.
That access drive right there is two-way, right?
That
Is
is a
that 24
two-way.
feet? It'd be the same as 24 feet.
Typically on your entrances, you wouldn't have those wider. That entrance would be wide out. You'd have, for that type of driveway, maybe 16 for the in-lane, inbound lane, and 14 for the outbound lane.
It does look a little bit
And you go
larger.
up to 40. So that's variable once you get inside, just like intersections on a road, it can neck back down, without.
Don't have any parking
So-
spaces in that area either.
That's the driveway.
What you are
Yeah, that's
doing,
the driveway.
So it's probably
so
50.
question, what your trucks are doing now, they're coming off Colthorpe this way, turning here and coming in behind the store?
So, I don't.
Can someone put the map
If you
up?
could move the, I guess I have to clear. So the trucks come in through the access easement, they come in off of Pleasant Road, drive up, does this have a laser on it? So trucks come in here, pull up, back in, and then they exit via the access easement
Okay.
out on Coulthard.
So they do have it, the trucks are coming in off of Pleasant.
We wouldn't be able to exit the property.
And they make their movements within your 24-foot wide pavement section and parking spaces.
I'm sorry, can you? I don't understand the question.
The drive aisles within the parking lot of Lidl out front, or Lidl, I may pronounce that wrong.
Yeah, it's legal.
It's
Lidl.
24 feet too, it's 24 feet.
That would be 24 feet as well.
Yeah, you can see that on the image here.
Yeah.
I can't read the writing there. Under the protective drive where it says access easement in red, protected drive, it's got 15 something.
Miles per hour.
Yeah.
Okay.
Just a point of clarification, if I could, Board. The site plan that you're looking at, the narrowest point on that access off of Pleasant it's very small print, but it's 30 feet.
That's the difference, but when they turn left and go down in front of the store, it's down to 24.
Right.
It's a tight turn for a semi, isn't it?
It is, but that's what it's got on the figure here.
Yeah, it is, yeah.
So it's
With parking.
24 in front of the store that where your trucks are going now on the route in off Pleasant, correct?
If that's what the site plan says, yes.
Okay, so if those parking spaces are allowed there and you're coming out of the dock, you turn right onto the access easement, would if allowed, in the parking spaces resulted in 24 feet, isn't that gonna be the same as what you're facing now in front of the store?
I would have to circle up with my civil engineer for confirmation. Our deliveries are typically made early in the morning, when there's no customers in the parking lot. So typically the 24-foot for just the drive aisle ends up being some into the parking spaces as the truck drivers are swinging. This is a perfect scenario with a perfect driver who can come in and not run over curbs, and which is not very.
There's not many of those.
Yeah, exactly.
Oh, yes, we can.
Well, if all parties met to come up with the original agreement, was there some discussion between the parties how to meet somewhere in the middle? Could some spaces be provided, but maybe a little bit more than 24 feet for trucks coming through? I mean, if there was an agreement once before, couldn't there possibly be some type of compromise? Or I don't know what that looks like. That would be for the parties to determine that, but.
Correct, but unfortunately, I was not here in 2017 when this original agreement was put in place, so I can't speak to what was negotiated or what was put, or any kind of restrictions that were put in there. Now, I was here when we amended the agreement and added the addition of the Home 2 suites. And our intention of granting them access to construct the road that we were going to was, the commercial access to their property, but then also to restrict that drive aisle for all future parking.
Any further questions? Thank you.
Thank you.
Anybody else to speak against the application, please come forward.
Good evening. My name is Joe Neal, attorney at Morton & Geddes in Rock Hill, 331 East Main Street, Rock Hill, South Carolina, 29730. I represent Home 2 Suite, the adjacent property that we've been talking about. We've got an existing hotel there on the property. Mr. Kimball's principal argument is that his client is not restricted by the easement agreement. I want to point your attention to the original agreement, page 264. section 3.1A, and he's already read through a good amount of this, but it continues on to say that in addition, each owner hereby grants and conveys to the other owner for the benefit of and appurtenance to the other consenting parcel, a non-exclusive ingress and egress easement over and across all roadways, sidewalks, parking areas, and it goes on to say, but not parking. This is a reciprocal easement agreement. And so, Mr. Kimball's client was not the only one that was granting the easement. Everyone was granting an easement to one another. And so, Mr. Williams, to your question, if there was ever any discussion of, well, could parking go here and could trucks fit through there was never intended to be any parking over this easement, over this 50-foot easement. And if I may approach and show you all, I was out on the property yesterday. One thing that's important to note is that this easement is not only for vehicular access, but it's also for pedestrian access. And so while the road is 24 feet, there is a sidewalk there right now for pedestrian access. And the easement agreement explicitly says that it is for vehicular and for pedestrian access. What they are proposing is to eliminate this parking, what they're proposing is to eliminate the sidewalk, which will be the pedestrian access, and put in parking spots. Goes against what the easement is for, goes against the express language within the easement agreement. Additionally, easements routinely restrict the ability of the property owner that grants it. An easement gives a third party the right to enter a landowner's property, thereby restricting the landowner's ability. That's why easements have dominant and servient tenants. The easement agreement does not contain any other provisions that give the applicant the right to install parking within the protected drive. Mr. Kimball cites a provision of the easement that gives the applicant the right to alter or relocate the protected drive. What's missing from this argument is that any alteration or relocation of the protected drive cannot interrupt the operations of Lidl or my client's improvements. As we stated earlier today, my client is the one that installed the asphalt and curbing that is now on the protected drive that I just showed you. And again, it's got to have adequate vehicular and pedestrian access. Lastly, the zoning administrator correctly applied the governing statute, section 629-1145 of the South Carolina Code, which states that the local planning agency must inquire if the tract or parcel of land is restricted by a covenant that is contrary to or conflicts with the permitted activity. The statute goes on to say that the local planning agency must not issue the permit unless it receives confirmation that the covenant has been lifted. We've got a representative from Lidl here that says the covenant hasn't been lifted. My client is the other party to the agreement. The covenant has not been lifted. Mr. Kimball cites subsection C2 and C3 that states that the statute does not apply to structures to be built upon a tract of land, and argues that the zoning administrator did not have the authority to render her decision. Section 629-1120, subsection 3 of the South Carolina Code clearly outlines the legislature's intent and the grant of authority to the administrator to assure the adequate provision of safe and convenient traffic access and circulation, both vehicular and pedestrian, in and through new land developments. The provisions of the easement agreement aside, the zoning administrator had the authority to render her decision because the applicant's proposed plan adversely impacts the traffic and circulation in the area. With that being said, I respectfully ask the board to uphold the zoning administrator's decision.
Any questions?
That first part you read, where it says over and across all roadways, sidewalks, and parking areas, but then goes on to say, but not parking. Isn't that contradictory a little bit?
Again, the 50-foot easement was never intended to be used for parking. And now, again, my client has, and I can show you guys another picture here, because I think that it was mentioned that there's currently parking that's over the easement area. And there's not.
Yeah.
And so here's the 50 feet. My client's parking lot is here, which is on my client's property.
Right.
So you can see, yeah, I mean, there's a gap in between. And I think when it's talking about, again, you don't want legal custom parking in your parking lot, but that has nothing to do with the access easement itself. That's our position. Thank you.
Thank you. Anybody else to speak against the application? Please come forward.
Hey, good evening. My name is Amar Patel, and I'm the developer and owner of the Home 2 Suites located at 1840 Coltharp Road. I am in strong opposition to the proposed hotel. You've heard the history, as many of you know. The access easement was built because Isom Road was abandoned, and the purpose of the easement was to service residential, commercial, and pedestrian traffic, but not parking, and also to ease traffic off Pleasant Road. The agreement between the three parcel owners, not two, clearly says that there's not to be parking on this access easement. Keep in mind, I constructed this road, which added a significant cost to my project and was also crucial to my project's approval. Again, this road was mandated by the county to allow access because Isom Road was abandoned. And it was not supposed to move in any way. The subject site plan wipes out the entire access easement and sidewalks and adds 61 parking spaces on and along the easement, therefore not allowing vehicular and pedestrian traffic. The proposed site plan appears to show that my guests would have to first enter their parking lot and then come into mine. Also, my guests will be subject to see their dumpster right when they enter the hotel. And I think when the dumpster is actually being emptied by the garbage truck, the whole road would be blocked. These issues will cause tremendous traffic and confusion and other problems that will negatively impact my business. Furthermore, I have about 20 signatures from residents in the subject area who strongly oppose another hotel coming there. And some of these residents are the same ones who petitioned the subject developer who tried to put the hotel just on the other side of Coltharp. Thank you.
Thank you.
Any questions? Anybody else to speak in opposition of the application, please come forward.
Good evening. My name is Walter Casket, and I live at 1829 Pleasant Road in Fort Mill, which is just across the street from this proposed hotel thing. Lived there a long time. Seen traffic increase like you wouldn't believe. This access driveway or whatever is going to be well used because most of the people that will go into or either come out of legal or home to or whatever are going to use that thing to go to Coltharp Road because there's a stoplight. Most times of the day, coming out of the access road on Pleasant Road and making a left turn will be impossible. It just in the same way from coming in the opposite direction. Cars are going to use that, and our traffic is terrible. And I think that a very busy access road into something, you don't want people backing out of parking spaces right into that flow of traffic, and it should be very busy. And also, I am very much opposed to changing the agreement that was made originally.
Okay.
Thank you.
Thank you. Anyone else to speak in opposition to the application?
Yeah, I'm Frank Petrosky at 1821 Pleasant Road, Fort Mill, South Carolina. I live catty corner from this situation. Right now, I've got a tree barrier reasonable where the hotel is, if I get another hotel right on the road, they're just looking right down into my house. I mean, I can just throw a stone across the street. And if they only needed 24 foot and think that was fine, why did it get 50 foot wide? There was a purpose for that, to keep the traffic flow so it don't get bottlenecked because of the two businesses there. When you make a little tight situation, you're like getting a little strip mall where nobody goes anywhere. And when they're talking about big trucks trying to get in there and you got people backing up and everything, these trucks can't go. They need this, that's what they call it, an access, so you can get there, not be in a traffic jam. So two reasons, I don't want another hotel there. I'm unhappy that I have to tolerate the one that's there, but at least I got a tree barrier right now. They'll rip all that out, then I got a hotel looking right down in my windows. And I can understand, like I say, if they only needed 24 foot, they should have built 24 foot. But you know, that's not sufficient when you gotta cater to two businesses back and forth with constant traffic flow, people buying and going back and forth. That's just my comment. I hope that means something. Thank you.
Well, thank you.
Hello, gentlemen. My name is Les Patel, and I'm also a developer part in it. I just said to add on to what my lawyer and my son said. I was involved in this project from the very beginning, and we were told by county and many of the meetings that Lidl plan is sitting right like this, and so does this access road. Nobody can change anything because the site plan is approved or is in the way to be approved. So we have to accept this road just the way it is. Cannot change nothing. Now here people are asking for changing it. It don't make any sense. I was also told that this road has to be just like that because it will ease off the traffic off of the Pleasant Road. And many of the people are going to drive through Lido and get on Old Thurrock, thus they will not be on the Pleasant Road choking up the traffic. And that's all I have to say. Thank you.
Thank you. Anyone else to speak in opposition of the application? Seeing none, would the applicant wish to come forward for any rebuttal?
Thank you. I actually would like to have a representative from the engineer who submitted the site plan come and speak to some of the ingress and egress issues that have been raised. He's going to be able to address that more authoritatively than I will, if that's okay.
Thank you, Board. My name is Brandon Pridemore. I'm a development consultant and engineering consultant with Arjo Harris Associates out of TPK, South Carolina. We're the civil engineer that's been helping Solera investments on this. Just hearing the discussions and arguments tonight, I wanted to clarify, I find it ironic that the discussion is we can't have parking, but yet if you look at the site plan Lidl has, they're not bound by the same condition. I don't think the intent of the agreement was to be weighted against the very entity that was granting the easement to be more restrictive than the person who's getting the benefit of it. But irrespective of that, I think we heard the discussion, how wide is this, how wide is this driveway path? What's 24 feet is what I'm seeing. We're preserving a 24-foot paved path. And really, when we talk about traffic, Lidl mentioned as well, they're going to come in early in the morning. Well, the question really becomes, from just a practical engineering standpoint, how many vehicles are they going to have early in the morning? I'm guessing one. So are we arguing from a practical standpoint that one truck at 6 o'clock in the morning is going to be hindered by the use of my client's property? But again, I don't see that we're hindering the use of that access easement. The path is there, the radiuses are there, we're keeping the radius intact, as a matter of fact, as it turns into Coltharp Road. So I don't know that from an engineering standpoint, we've altered anything. And I just wanted to clarify that for the record. Thank you.
I have a question for you, sir.
Yes, ma'am.
So if you put these parking spots in, will the pedestrian sidewalks be taken out and not replaced?
They will, but I mean, that's something, if it's one of the conditions we gotta work with, we'll have to reconfigure that and refigure that out. So, I mean, that's a separate issue. I don't know what the intent was. I do know, just for the record, I was 4-Stars engineer when they purchased the Habersham property and this property as well, and I did a lot of consulting for them early in the discussions with Lidl. And I can tell you firsthand, I don't think there's an intent that they're going to restrict themselves to the point where they can't benefit from this being there. But if that's a condition and will of the BZA that we do need to carry pedestrian access through there, that's something we'll have to consider and figure out how to do it. So it's not that we're asking you to approve the plan that we submitted. What we're asking you to approve is the right for us to put the parking in the easement like
Correct.
we feel the agreement allows us to do.
I posed a question earlier about potential parking within the footprint. Might have first two levels of the hotel as parking and go higher.
And that's a good question, but we also have height limitations in York County. And so that's it's very expensive to do, and it's putting a burden on our client's property that the other properties aren't having to do. It's just, from the structural standpoint, it adds a whole nother level. And keep in mind, York County has a 50-foot maximum cap on the building height. We couldn't build the facility they'd like to build and be able to do that without running afoul of that height requirement.
All right. Thank you.
Thank you.
I may just address a couple points that were raised. First of all, on the pedestrian access, I'm sympathetic to that, and I believe, I can be corrected if I'm wrong, that we have submitted another version of this plat to the county that has sidewalks, and I believe that's in your packet that was submitted with our application. Let me see if I can give you a page number for that. Pardon me. Yeah, there is a revised plan with sidewalks that shows we're going to include those pedestrian walks for exactly that concern. So we're sensitive to that. To emphasize a couple of things here. First of all, as you can see with Vital's site plan, the point was made, and it's a good one, that they are effectively objecting to our doing exactly what they have up there. They have 5 aisles with parking adjacent. They have, I can't see the numbers, I can't read microscopic print, but it looks like it's 20-something feet of access. That's what we're preserving. I need to be totally clear about that. We are not restricting that 24-foot drive area. That's going to be maintained completely clear, just with parking on either side of it. So there's going to be no restriction to ingress or egress that would affect the access to the parcel. Third, and I think finally...
Excuse me. Please hold the conversations outside. If you need to have conversations in this room and not at the podium, please go outside the room, please. Thank you.
Third, and I think finally, if you could look at the map that I gave you in that handout, on the very first page there, it shows, the second page, it shows the radius up at the top of the site plan and where it goes into the Home 2 Suites parcel. Note that that access is above all of the parking except for 3 spaces, I think, that are being discussed here. So Home 2 Suites site is not really being affected by this at all. And I just wanted to point that out because I think it's disingenuous to say that they're going to suffer as a result of this.
Okay.
Unless the board has further questions, I would just, yes.
Was there a consideration of parking on one side versus both?
One side versus both.
Because you mentioned putting parking on both sides of the road that's in discussion now.
Right. I don't personally know if that's been discussed. I don't know if that's possible from an engineering perspective.
So if you can put more, but from an engineering perspective, you don't know if it's possible to put less.
I think there was a limitation on the number of spaces that are
So
required.
they have to have.
They have to have so many spaces.
Okay.
I misunderstood. I see what you're saying. Yeah, there's a number, if you're gonna have X number of rooms,
You gotta have X number of.
spaces. That's the issue there, yeah. Unless there are further questions, I would just reiterate our request that the staff decision be reversed. My client here would like to speak, if that's allowed.
Yep.
This is Clarence Kyle, he's the sole member of Solari Investments and Property.
Thank you. Good evening. I wish we could see a little bit more. I'd like to address the little
address the trucking philosophy that he had regarding how trucks enter and exit the property. I've owned over and operated 20 or 20 some hotels, and if we get to the left, there's an access that goes in, and if it's to the left, and it goes straight into the home too, and it goes to the right to the drive-out access easement. In my opinion, based on my experience, I don't think trucks would try to make that hard turn to the right. I don't think there's enough space on the curb, on the access to get in. We would have to probably work with Home 2 and maybe possibly get rid of some of those spaces if that's the actual way the trucks would enter. I'm not a truck driver, but I have noticed when trucks come in, they take the easiest route. And I don't think coming into that access easement and making that curve to the right bend, I don't think a truck can make it through there. But they can make it through a 24-foot driveway. But why wouldn't the truck go straight in off of Pleasant Road? And I don't even know if that's 24 feet or not. If it isn't, I don't know whoever approved it, if that's okay with them.
It's 30 feet coming off.
30 feet. So why would a truck not take the 30-foot way in, make a left, and it comes in early, comes in late? Why would they want to go all the way to the access easement when they can make the easiest route to get into the store site is to go off of Pleasant?
But he made the argument they are coming in that way, but they're
How do we
leaving.
know they're coming in? They're not there yet.
Well, but are you there if they're not?
No,
I
I'm
mean,
not there.
who's,
I'm just saying based on my experience is what I'm saying.
but he's saying based off
Okay.
his.
Okay, well then we disagree there. But I'm just bringing it out that I think the trucks would possibly go the easiest route.
But looking at that picture,
Mm-hmm.
taking that right out of that parking, out of that loading dock,
Right.
that appears to be a gradual curve versus.
Well, you mean coming out of the thing?
Correct.
Yeah, and I can see that. I'm saying entry.
The gentleman from Lidl said they would enter off of Pleasant and then
Okay,
exit it.
okay.
So y'all are saying the same exact thing.
Right.
The only thing is, the question I had was that curve is very difficult, I think, coming out of that was designed. If you see, it's not up there. Off of Coulthard.
Okay.
The turning radius to get to take that access, make a left or right.
Which would be out here. This is Coulthard.
Going a little bit beyond the purpose of this hearing as far as looking at traffic flow for trucks. I mean,
We'll bring it in here.
yeah, let's bring it back into the question at hand.
If there are no further questions, we just reiterate our request.
Thank you. All right, public hearing is closed, and I would like to say something before we, or at least maybe ask legal, not legal. I think, well, I'm hearing a lot of kind of arguments one way versus the other, and there's a lot of things to digest, and I don't feel comfortable making a decision right now based on the limited reading that I have done. I don't know about the other guys. And can we postpone the determination until the next meeting? Or sometime between them?
Mr. Chair, yes, you can take up a motion to defer. And if there's more information that you want, you can specifically request that the applicant and/or the staff provide you with more information prior to the next meeting date and hold further discussion at that time.
Well, I think it's a matter for me, just reading it a little bit more closely. Make sure I understand. I mean, this was written by lawyers, took them a lot of time to put it together, and I'm no lawyer.
Well, but wouldn't the issue be, even if we had more time, you have one lawyer with one interpretation and you have another lawyer with a different interpretation, do we feel 2, 3, 5, 10 days, we ourselves individually are gonna come up with a determination other than what these lawyers have, other than maybe legal advises us based on what's written here. So that's my thing. You've got two lawyers, and that's what they do every day. But am I going to read something here that makes me side with one over the other if I have additional time? Versus if can we determine that?
And to sort of bring it back together a little bit, it's like the last one of these we had. We're only voting
Parallel.
whether to uphold staff's decision or say staff was incorrect in their decision. The traffic flow, whether it's 25 or 20, and I want to be clear with staff, is staff's, was the rejection based on the parking or based on the width of the access road portion? It sounds like it's parking when I went back and looked at that. So the discussion is, do these agreements allow parking along that road or not allow parking along that road?
Right.
And did staff has said that they do not allow parking. Do we think staff was correct or incorrect? And I don't know that, I could spend 2 weeks reading this, and I still couldn't make that determination because there's so much legalese and
Correct.
and
that's my point.
I don't think I would ever be comfortable.
All right.
I'm not an attorney. So that's my 2 cents anyway.
Well, I think part of what Al's saying too is we didn't get all the information till tonight or this afternoon. We didn't get the amendment, we didn't get the maps, we didn't get some of the information that we didn't have time to really look at. And to me, I'm kind of along with Al. I would kind of like a little bit more time to look at it and after hearing the applicant and the opposition, they both make very good, valid points.
Well, I guess my question now would be, if they didn't agree and work it out, but if we agree to uphold staff's decision, then they're gonna have to, whether it be in the courts or whatnot, they're gonna have to work it out ultimately. So the decision is, really, are we just gonna uphold staff and then they're gonna have to ultimately work it out? They could have done it prior to coming here, but if we uphold staff, then we basically hand it back to them to say, now you've gotta go and legally work it out.
Mr.
Whether
Chair.
that's in the court or where.
I'm sorry for interrupting. I was just going to say, at this point, it's probably best to ask for a motion one way or the other and then continue discussion.
All right.
Good point.
Then I make a motion to uphold staff's interpretation.
I'll second that.
And again, look, when I'm looking at this, there is definitely a lot of words to say, but not parking. And I get the point over here, saying, why would we restrict parking on our own property? But again, the amendment to it for 2018 says all parties, says all owners, I believe. Well, that's what Lidl, I'm sorry, Lidl and hotel. There was something, number 7 on page 413. Access easement to property owners conveys to property owners and to each of the hotel parcel. There's a little confusion on wording right there. But it does say, but not parking.
For me, the legal documents are not clear enough to say that staff is incorrect at this juncture.
Yeah. So
I would agree. I don't think it's clear enough either way for us to make that determination that staff was incorrect in the decision. So,
Barbara?
My biggest issue is there's no place that says that the protective drive, other than on this map, is 24 feet. There's nothing that's stated that.
Does it actually say it on there, 24 feet?
Well, it says protective drive, and
No, 24 feet there.
true. Not on this map, which is the one he referred to. So there's just a lot of gray. And I guess I would have to go alongside with my counterparts here and say there's not enough to overturn it.
Any further discussion? All in favor of the motion to uphold staff's interpretation, raise your right hand. Unanimous. All righty. Next case is E21-14, Stewart, Inc.
I think that's it, what, 9, isn't it? Maybe these will go quick.
No, maybe not, because I'm gonna talk. This is my street. Thank you.
Good evening again. We have up for you a special exception request. The applicant is Stewart Incorporated. The property location is on Hands Mill Highway and Allison Creek and Vista Road. It is 3 parcels. They were recently rezoned Monday to AGC, so the zoning map hasn't been updated, so we see that. The request is allow a campground in the AGC zoning district. Campgrounds are only allowed by special exception in AGC. This is existing access area, Allison Creek access area, that's proposed to be expanded out to be a larger park with more amenities. And part of those amenities is the campgrounds. You can see here the zoning map, again, is now AGC, the parcels that you're seeing combined. And this is the aerial. There's a Duke Energy easement running across the property. And again, this is the Allison Creek access area. This is an old plat of the property, kind of showing the, it actually shows the access, the utility easement and Lake Wiley. This is another overhead of the property. There's existing boat launch, parking. I think there's a fishing pier. Of course, the project also entails other amenities being added to the park, in addition to just the camp sites. Topographic map showing the different parcels. This is a conceptual plan the applicant submitted when they were doing the zoning application. This is essentially what the site plan looks like as well. You can see in the sort of northern section a proposed area of RV parking. There's also a smaller area, it's a little bit hard to see, but there's a zoom in later, of tent camping. And RV camping, tent camping. The rest of the amenities here you can see is picnic areas, there's a ranger station, bathrooms, parking, boat launch improvements, parking improvements, and fishing pier, walking trails, and other amenities that serve the park. Here's kind of an overall site plan that the applicant submitted. Again, you see the RV parking area, kind of circular area here, kind of right past the Duke Energy. This is a Duke Energy project along with, and the applicant, of course, is the engineer. So we have an RV parking area, and this smaller area right here is like tent parking, tent areas for tents, and then there's some bathrooms and other amenities provided. This is a zoom in. You can kind of see where the tent camping would be. And again, this is just for the camping part of the park, not just for the park. That's an overall project, but it does involve, because they're proposing additional work with the camping is the canoe and kayak launch, a ranger station, a gatehouse, bathhouse, picnic shelters, playgrounds, trails, and other amenities. The total area of the parcels are 164 acres. And this is sort of a zoom in of where the RV camping is proposed on the site. In the staff report, section 155.022B12, which is a special exception in the AGC, lists some requirements in addition to just the general requirements for campgrounds. I could go through these, but I could just let you know that staff believes that these have been met or in compliance as far as the approved. Go ahead.
Under B, B, talks about ranger station for caretaker purposes.
Right.
Single. So, is that required, or it says it may have, because
They can have, this ordinance, this is, these campgrounds are accessory to the park, but some campgrounds are specifically just a campground, and they sometimes have caretakers, like an actual house on the property, or something like a single-family home, that somebody could live there and take care of the property. In this case, it'll have a ranger station, so it's not required, but it is an option if you have like a campground that needs to be monitored and you want to have a living quarters on the property.
But the ranger station is not a residence.
No, in this case, it's just for caretaker
A store
purposes to watch after the property, but it's not a residence. That's not what they're proposing. Let's see. Again, staff believes that the requirements of the preliminary plans, site plans that they've submitted are in compliance. Also, when looking at a special exception, there are 3 criteria that must be met. Are adequate water and sewer facilities provided? There's been a civil site plan submitted. It's showing water and sewer and electrical, of course, and it's being reviewed by staff, including York County Engineering. So the proposal is to have, county water and sewer to provide the services, and so staff believes that it does meet this criteria. The second criteria is, will the existing public services and public facilities, including but not limited to recreation, education, transportation, and water and sewer facilities, be negatively impacted by the proposed use? It is a recreational facility, it's a park. So staff basically believes that it's not going to have a negative impact, and it does meet this criteria. Number 3 is the proposed use compatible with surrounding uses? The property was just rezoned by the county council for this park project, including the camping aspect of it. And so staff does believe that this criteria has been met, that it has been looked at and been shown to be compatible with surrounding uses in the area. We do have one, if the board chooses to approve the special exception, one possible condition is we counted up that there would be 34 RV camping spaces and 18 tent camping spaces shown on the preliminary site plan. We would ask that the board states that that's the number that you're approving as far as the camping, if that's what the applicant wants. That way, if there's questions about it, it can expand in the future and things like that, this special exception would be for what they're proposing and not for future camping sites unless they come back to the board. Go back to the overall site plan. As you can see, it's the location of the property is between Hands Mill and Allison Creek Road. And I am open to any questions.
Okay, I live off of Allison Creek Road, and we have some concerns about the overall project, not just the camping, but first of all, just to make my fellow board members aware here, Allison Creek Road is a 5-mile, 2-lane road, one way in, one way out. It currently has about 450 homes on it. with the addition of the approved Lakeside Glen development, which is directly across from Allison Creek Road, and it goes about 3/4 of the way down the peninsula. It's going to be another 425 homes, which doubles the size of the peninsula. The speed limit, the access point is Viesta Drive, and right now, as you mentioned, there is a boat landing there. It's on a curve. There's a blind curve, as you can see, going towards, coming from Hansville Mill, going to the end of the peninsula. There's a blind curve there. 45 miles per hour. You have people exceeding that by 10, 15 miles per hour. It's a speed road. We're within 1 mile of the Duke radius, the Duke nuclear power plant. Also, the intersection of 274 and Allison Creek Road, there's no traffic signal there. That is a 55 plus mile per hour road, which I say plus because they are going 60, 65 down 274. Either way, there's a blind hill and there's a blind curve. Basically, if you take a left-hand turn out of Allison Creek Road, you have to turn into the center lane and merge because you cannot see traffic coming in because they're going so fast. It's the only public boat landing within miles. The closest would be Buster Boyd, and the other closest would be Ebenezer. So it's going to be highly used. It is summer months. It is crazy there. You have traffic lined up on Allison Creek Road to make a turn, left-hand turn onto Viesta. You double the population times 2 cars, you are going to have a nightmare of a traffic situation. There is a church at the intersection of Allison Creek Road and 274. 9 months out of the year, there's a preschool there, 100 plus students. The staff parks on one side towards the soccer fields, and the kids are dropped off at the church. From 8 o'clock to 8:30, it is backed up, and noonish, it's not as bad because you don't have people going to work, but you have drop off and pick up. It is quite congested there. No stoplight. So that's where I'm getting to. Additional developments coming within a mile of 274. You've got Westport development that's 800 plus homes. You've got the Daimler Road, which is another 3,000 plus homes, plus a high school. The HOA monitors sheriff's calls. Probably 50% of the calls that we get to the sheriff's office is in direct, is pertaining to calls on the landing. So I have to agree, security will be beneficial. I think it will decrease the number of calls and things going on there at the landing. The other thing, my biggest gripe is there is no light. Now, when they do put in Lakeside Glen, and maybe someone else in staff can answer this, they are required to put a light in. Now, I don't know when Lakeside Glen is going to be, they are surveying right now. I know it's a 6-year project, so you included with all this boat traffic and RV traffic and just the resident traffic, you're going to have construction traffic on top of it for 6 years. One of the things that I think is critical is even if Lakeside Glen, is not underway before this before this is put forth or before it's going through, there has to be a traffic light at Allison Creek and 274. To me, that has to be a condition. I know it's also been brought up of putting a second entrance into the peninsula. I know Allison Creek is a state road. I know it's, a CDOT has to, approve all that. I know that's probably unlikely, but, I'm just throwing it out there, see what can be done. At least put the light in, and also, as you leave Allison Creek, as you egress and ingress, it's 1 lane in, 1 lane out. So if somebody's making a left-hand turn, which, as traffic is increasing down 274 without a light, traffic is backed up. You've got the church, you've got soccer fields. It's a mess. So I am just letting my fellow members here know that, the TIA says, you know, you're gonna have 4 additional here, 7 additional here, but it doesn't talk about everything else that is going on and will be going on in the future. So I don't even know if it's even feasible to put a turn lane, a left-hand turn lane into Viesta, but something has to be done with the traffic pattern on Ellison Creek Road and it's onto 274 and even going into this park. So I'm just letting everybody know.
I called too and asked, I want more detail on the TIA that was done. And my question is, it's like they submit a preliminary meltdown, no data version. Who did I talk to? I talked to you. I talked to somebody about, who did I talk to about the traffic? You, I thought, yeah. And then my point was that too, is it needs to be a red light there. Now, as everybody knows, South Carolina DOT has to put the light up.
And it has been promised to us once the Lakeside Glen, but if this precedes it, there needs to be a light there. I mean, it's a death trap.
But if the county puts pressure on, which they never do either, the DOT will move faster sometimes, if you think. But I had another question too. On this campground, how's the sewer service being provided? Is it going into the force main to Rock Hill? Or is it being in an independent little old cesspool over there?
I think the applicant could speak more about the details of how they're going to, you know, have the services, but on the site plan, it does show running down, Viesta Road, water and sewer service, and electrical, which we confirmed will be underground as well.
So they're gonna put a pump station and jump in the force main?
And, yeah, and like I said, I would like to, I think the applicant could speak more about the details, but I know they're working with our York County engineering on actually working on not just the utilities, but the road as far as coming into the site.
Well, it seems like y'all in a fast track to prove the thing. She's got a very legitimate point. And that's somebody fixing to get killed on them blind hills. The more people you have coming out. But the special exception permit requires a sewer plan.
Mm-hmm.
Where's the plan? Oh, they're working on it. We're going with engineering. Well, you come back when you're through and with the plan.
The applicant has submitted plans which include showing the water and sewer system. It's in review. It's not obviously been approved because even the campgrounds haven't.
But we're required to say, where is it? Because that's a requirement of a special exception. So we're supposed to see that. But yeah, where that comes from.
I don't have a zoom in of the utilities with this, but it is.
Well, you answered my question. If it's going in the force main, that's good, rather than a poop station. But then the other part is on what she's bringing about the light. Yeah, you can't. It's already a zoo. They build that one across the highway. That is, if anybody's ever driven by Hill Ironworks knows that hill you can't see. I know that it won't happen, but can we put a condition to put the pressure on Duke Power and all this? Duke Power has to do this campground.
Yes, they do because of the licensing, right?
And so why don't we use put some pressure on them to put pressure on DOT at the same time? It's crazy, it's bizarre, but it's worth a try, because if you don't, it'll be 5 or 10 years before DOT ever puts up a light. That's just the reality.
If I could answer a couple of those traffic questions. My name is Christopher Stevens. I'm the York County Transportation Planner.
Yeah.
So in order for a light to come in there, you have to meet DOT's 8-hour warrants. So currently they won't meet the warrants. And even with the campground, they still wouldn't meet the warrants. And so based off of that, you couldn't get a traffic light as it currently stands.
I thought we did pass that. I thought we hit the number.
No. When Lakeside Glen comes in, DOT is requiring that they put the traffic light because they're going to bring in more trips. And so under final plat of any phase, the light has to go in before any trips are generated. So that's their requirement. And as a county, we can't dictate, when a traffic signal goes in. And even sometimes, even when a light meets the warrants, DOT doesn't necessarily mean, they'll put the light in. But on this case, they did say that the light will go in on the first phase or any phase of Lakeside Glen.
Okay. Well, I will make a note. When they do the traffic counts, it's It's not during the school year when the preschools are being picked up and dropped off. It's usually not during high boating season. You are gonna have RVs, trucks with trailers, with boats. We're talking longer vehicles. We're not talking, a station wagon or an SUV. And
And you only have your flat tire on the way back from the boat landing. So, it's, it's a legitimate point. I'm just throwing it out there too, is that there needs to be a dang light up there. Okay, bottom line, and
I'm
everybody
sure
knows it.
you know the situation, I'm sure.
Right, and so, like I said, when the larger development comes in, the light's coming.
That's what I say, so anyway, put the screws to them now.
Right, proceeding.
Well, but you wouldn't meet the warrants now, so if you put a condition that they had to have the light, they can't put it in now because they don't meet the warrants.
Did you say the light would go in as the new development?
So Lakeside Glen.
Begins development, not begins occupied.
Any final plat of that, the first phase, it's required is what DOT is requiring.
So when they start construction, the light has to be there.
But we don't know when that's gonna start, and this could precede it, and you're gonna have.
Well, again, we won't have any control over that.
So this development wouldn't put them over the number threshold.
This is a very small development from a trip standpoint. This is a tier 1 TIA, and so that's why you don't see as much data because it's a smaller.
But is it always simply based on number? Because as Barbara mentioned,
it depends the time of the year.
The circumstances that it creates, versus, hey, all of the numbers, but.
Well, some of the traffic is kind of already there as people are using the boat ramp currently. And so you'll add a little bit with the campground, but it's not enough to trigger where, a light or something like that is coming into play.
And Mr. Chair, if I might add to what Christopher is telling you, is on top of all of that information, when the board adds a condition that requires an off-site improvement, that is an exaction. So you need to make sure that the exaction that the board might require is directly attributable to the impacts of the development that's being proposed. So in the instance of Lakeside Glen, that's why they are being required to put in the traffic light, because they're building homes. The number of trips is infinitely higher than what this campground will add.
Oh, yeah.
So that's why they are being.
Understandable.
So that's why they are being required to add the light. You don't want to necessarily require an exaction for just the next person in line because the background traffic is already so high. They need to be, the exaction needs to be attributable to the effect that the proposed development is adding.
Okay, so you're adding 32 RVs, you're extending the boat landing.
I understand that you can have the board can have its own opinions about that matter. I'm just adding that.
And they're gonna have to make left-hand turns too, and right-hand turns.
I'm just, and I'm really just throwing it out there to see if y'all make it stick, because if Duke Power got a wrench thrown in their little party, then the phones would start ringing in Columbia, is only what I'm saying. That's how it works, or find some guardrail up there that Leatherman can sell, and it'll go in that way.
What's the current zoning?
The current zone is now AGC.
They just passed it on Monday.
Okay. Well,
Third reading.
Okay. What was it zoned?
It was AGR, wasn't it? No, it just. RD2, yeah, that's right. That's what the rest of it is. Yeah.
Any further questions for staff? Thank you. Would the applicant please come forward?
Hi, my name is Emily Blackwell. I live at 619 Raphael Place in Charlotte. I am the landscape architect project manager for Stewart, working on behalf of both Duke and York County. One thing that I don't think has been discussed here is that this is actually a joint venture by Duke and York County, and it will be leased by York County as a county park. So the expenses of all the facilities are being split based on what is actually required by the FERC licensing for Duke to do and what has actually been requested by York. One point of clarification, I know you guys are working through what's required and what's not. The RV camping is not explicitly required by the FERC licensing. It is required if York County leases the property.
I'm sorry, repeat that?
I confusing. I was texting to make sure I had it right too. For the additions that are being added to this property, the primary agreement with Duke and the federal government for providing recreation on the site does not initially require RV parking. It is the fact that York is going to lease the property that then brings that as a part of the conversation.
Right.
A little rusty on those exact relationships, but basically that if RV camping were to be not allowed, York County would not lease the property and the property would not become a park, not become a county park.
Right. Which means
In which
probably
case,
no
you're
security.
basically killing the whole project.
Right, no.
Because of the financial agreements that have been made. The tent camping is an explicit request of, I know y'all haven't really been addressing that much, but the tent camping is an explicit request of York County to be added as part of them agreeing to lease the property as a park. So a little bit complicated, and I can probably phone a friend if I need to get a little more in depth about that and make sure that I know all the details right. I think the other things, and I think staff has probably already addressed everything I would have said about the TIA. I understand your concerns about Allison Creek. We've just gone through the rezoning process, so those concerns have all been brought up. I actually wasn't, until we were going through rezoning, aware of the big development going on across the street. So, obviously our TIA says we don't need to make improvements to the road or to the intersection or to our entrance drive. We understand that will come, as you guys have discussed, with the new development across the street. But I guess the statement is that we don't have a requirement to make those through this project. The property has already been rezoned, as was stated, and so the county council is in agreement with proceeding with this project, and obviously the county is proponent, the county staff, county as a whole, government-wise, is a proponent of the project since they are entering into a large financial agreement with Duke to pay for these amenities. The only other thing I would mention, we are not expanding the boat ramp, so what facilities are there is what is going to stay. We're reconfiguring the parking a little bit to make traffic through there easier. Particularly as we are adding, the thing we are adding in that area is a canoe kayak launch. But otherwise the rest is just to kind of make it a little easier to maneuver and adding a small restroom building there. I think everything was covered regarding utilities, so we are tapping into county water and sewer, and there are multiple pump stations on the site because everything is low ground. It's got to get back up to the high ground of the road.
There's a pump station right across the street.
Okay.
Who said that?
I did. There's Little Allison Pump Station is right across Allison Creek Road.
Hooky butt.
Yeah, just a fact.
Yeah. So we're having to pump it from the far extent of the site back up to the road. That is, I think I'm trying to go through all the things you talked about. The ranger station does not have a residence in it. It's going to be very much like the one at Ebenezer, where there's a store, an office, and a restroom. I can't answer from a programming standpoint whether York County Parks is planning to have a kind of a campground host or not. They have not asked us to designate a spot as a campground host or putting signage, so that is kind of like, just something they haven't decided on yet.
Is the security, is it going to be 24/7 security though? I mean, it looks like there's a gate. So
there is a gate.
Which is access both the boat landing and the camping, because it looks like it's before it splits off.
It's on the main road. My understanding is that, once you're in for the night, you're in for the night,
Okay.
I don't exactly know how they plan on functioning the gates in order for emergency exit, but I assume you'll be able to get out, but you won't be able to get back
Okay, and I don't know, maybe does staff know that? Because we were under the impression, when I say we, the residents were under the understanding it was gonna be 24/7 security.
And I just can't speak to the program as to whether they're gonna have somebody in that booth all the time.
Yeah.
I know that you won't be able to, you're not gonna be able to get in unless you're camping there.
Okay.
I don't know exactly how they're gonna make that function, I apologize.
No.
But the intent is to keep the site secure.
Mhm.
You have a trail going to Allison Creek Presbyterian Church. Was there some agreement set up for that?
Yes, I was not directly involved with that, but my client with Duke Energy have worked that out. And you'll see there's kind of a semicircle connection. Anyway, one of the northern one of those two connections on the west side, we did get some feedback that was sent to staff, that the northern one is slightly not exactly where we intended it to be, so we're gonna move that one a little further south so that it stays on church property. It is kind of connecting right at the corner of a property line that's, one property is the church's and one property is private property, and that resident reached out, and so we're gonna make that adjustment.
There's, when I was looking at this, thinking about Bassmasters fishing tournament. They've had it at Lake Wylie, okay? They've got it at Lake Hartwell coming up soon. Are there any discussions, I was talking about traffic, the concern for traffic, and then is there any discussion of having like a fishing tournament such as the Bassmasters? That would be York's responsibility, so, okay. They would be making that call, I guess.
Yeah, we haven't been asked to make any accommodations to set it up for a tournament. I know in earlier design layouts for this property about 10 years ago, there was, I believe, an additional shelter to be added near the boat ramps for that intent, and that is not in the plans yet.
Okay.
And you mentioned the access or the area itself being secure, but not specifically security. And here's how I'm thinking about that. A storage facility would tell you they're secure because they have gates that you can't get in and out of unless you have paid permitted access. But that doesn't mean there's security there.
Right.
So to Barbara's question earlier about the calls that are in the area now, if you bring in X number of additional people without actual security, is there someone there monitoring what,
I know, I can tell you what I know, and then I would probably need to reach out to Teresa Bass, who is the, Teresa or Lisa Haygood, who would both be kind of the people that I would answer to on those, on exactly how they're gonna staff the site. I know that we've got a ranger booth at that entrance where the gates are. I cannot state what their staffing intent is, if they're gonna have somebody there, 24/7. I also know that they are working currently on a plan for adding security cameras and video monitoring at the ranger station, and planning on putting cameras at strategic points on the site where, particularly where the facilities are on site. I don't know if it's only going to be monitored by somebody on site or if it's going to be monitored off site. Apologize, I can't speak to exactly how they plan on staffing that. Great question.
Do you have any information on the adjoining or the development across the street?
I don't have any information.
Okay, that's probably a question for staff and how those driveways will align and all that.
Right, yeah.
Is
Yeah,
it
'cause
correct, is the
we're
big
intending
development
on
across
using
the street?
existing-
It is across the street.
Directly
It's on the south side of Allison Creek. It's the old it's Crescent, and it's Fielding bought it, and they're doing the surveying right now, and it's 425 homes.
Yeah.
And
There'll be a lot more traffic than this.
yeah,
Oh, yeah.
because there's one way in and one way out.
All right, any further questions? No, thank you.
Thank you very much.
Legal. Do we have a public hearing for the special for this type of?
Yes, I would go ahead and ask.
Okay.
if there's-
Anybody here to speak in favor of the application?
My name's Matt Brightwell. I live at 1780 Old Clay Hill Road. I'm on the point right there. Hi, neighbor.
Hi.
I feel your pain.
Thank you.
And I'm not here to speak in favor, but I'm also not here to speak against. But those are the only two options presented to me, so I would like to beg your indulgence. I will be brief. I just want to make a couple of statements. One's rather selfish and one's somewhat altruistic, and just to get on the record with a personal appeal for Ms. Blackwell. By changing the zoning from residential to agricultural, this is the selfish statement. From what I understand, we're on the edge of Comporium's telecommunications district. Across the highway, across 274 is AT&T's territory, and across the creek is what used to be Time Warner Cable, which is now Spectrum. Okay, so Comporium only comes down as far as Allison Creek Church Road. So they won't provide, by changing it from residential to agricultural, Comporium wants 13 houses to come down the hill and provide, fiber optic cable. And that can no longer happen because everything's just been rezoned agricultural. So my appeal to Ms. Blackwell is for them to incorporate some money into their site planning budget to, as a show of good neighborhood community, to run fiber optic cable down the hill for us. I know this is nothing you can do. This is just me being on the record. My other request would be, what's not shown on this map is there's a little island off the side of that point that over the last 10 years has been decreased by half in size because of all the recreational boating. And it would be really sweet if Duke Energy would put a no-wake zone out there to preserve the rest of that island so that the blue herons can maintain a place to live. That's all I got to say. Thanks very much for listening to me. I think it's going to be a good project. Putting a sheriff's deputy at the ranger station would not be a bad idea. Thank you.
Thank you. Anyone else to speak in favor of the application? Anybody to speak against the application?
My name is Edward Oliver. I'm at 145 Mariners Bluff Road. I actually live on that cove that's there. My concern is the security. There's between fires and garbage and the kids that like to back into the lake and then go for a half hour. I almost hope that they run out of gas. So we'll call in at times, and the amount of garbage that ends up in the lake from the people that are there now is a lot. Security, if it's between 8 and 5, that's not when anything happens. So it's got to be round the clock. That's really my concerns.
Okay, thank you. Anybody else speak in favor of or against?
Oh, one small thing if I could. Where is the proposed tenant?
Excuse me, the proposed,
An area, I see the. And then those other things are walking trails? These are walking trails. Okay, great, thank you very much.
thank you. Would the applicant care to make any additional remarks?
Sure, I'll just respond to those. We'll definitely pass the feedback on about safety. I think that came up in the rezoning hearing as well. So that's appreciated. I'll definitely pass that along to your county staff so that they can use that to inform their decision. Because I think they're aware of some of that. I just don't want to speak on their behalf as to whether there's somebody there. I don't want to tell you guys
Sure.
there's somebody there
You don't want them to
all
lead
the
us.
time, and that's not their intent. I know that with this project and with the addition of the gatehouse, everything, there will be, security and those issues that we've been hearing about from vandalism and, partying on the on the point, issues should definitely decrease. I did not know about the island thing, so I just gave this gentleman my card. If you can pass it, send me a screenshot of where that island is, I'll definitely pass it on to Duke, see if they can put some signage out or what they can take it on forward on what their process is. I can't do that, but I will definitely pass the message on. And then fiber, I will bring that up to our client team with York, because that may be something that will benefit them for their security system as well. So I know that they are going to have telecom on site that will be serving that. So I can't promise anything, but I will pass the message on. I think I addressed everything. Is there anything else you guys have questions on, or?
Not for the applicant. I have a question for the staff, but.
Thank you.
Thank you very much.
Thank you.
Okay, so I just want to make sure I'm self-clear. I cannot make anything conditional on a turn signal because it's not warranted at this point.
Well, I got a question for legal too on that same thing. This is a state legislative board. The county council's power is to appoint members to this board. We're to review and reverse or whatever, variances as their constitutional right of appeal to their decisions, okay? Mm-hmm. They dumped special exceptions on this board years ago because of landfills. They won't deal with it. Mm-hmm. And so, you have to do that. So I'm not giving up on your red light because you're right about that. Is that, why can't we put a condition on there since the county council does not? This is a whole different board. That's why we are not able to pass on vested interest and all kinds of legal things. Why can't we put the screws to them and make them, Duke Power and the county do something with DOT and put a light up? I'm not gonna give up that easy. I guess what I'm getting.
I hear you. I hear you. But I would say, I would be hesitant to put an obligation on Duke Power and the county to do something they cannot do. They cannot put up a red light.
Okay.
Until it is warranted by the DOT. Well, they cannot. They have no ability to meet that requirement until SCDOT says you can put a light up there.
Okay.
They just can't do it.
Would you agree then? I mean, that's basically what it.
I've been through that a bunch. Where lights are needed and the DOT will not say it's warranted. And I mean, I've had developers say, I want to put up a light, and DOT say, no, we are not going to let you yet.
Mm-hmm. Yep. Well, it's worth putting the pressure on them, if anything, right?
I'm just trying to find, because it's kind of stupid. I mean, how many 160s and Sutton roads and everything else do you have to do before you go? Anyway, I'll try.
No.
I hear you. And I mean, you can do that. I would be hesitant to do that.
I just wanted it for the record, just so people are aware there are issues and they are not being addressed.
I have a question too as well. So y'all have seen the development plan for across the street because the DOT is requiring a light as part of that development. Is their main entrance going to align, and what improvements is the DOT requiring there, if any?
I can't remember exactly on those plans where, as far as where the road, I know that the spacing, we'll make sure the spacing meets the county's spacing requirements, and so for what I remember, they meets the spacing. It's either aligned or it meets the spacing requirement.
I would hope that it was aligned, and they're potentially doing some turn lanes and things because of the number of trips that development's going to generate. But that's sort of between y'all and the DOT.
So is there going to be any improvement when Lakeside Glen, because I know there's not going to be a second entrance, is there going to be any improvement to the intersection by the church where there's at least a turn lane going, egressing off of Allison Creek Road, like on Concord Road at the light?
Right.
Concord Road has the light, and they have a turn lane, a right-hand turn lane.
I don't recall if there was a turn lane there. I believe in another report, a recent study from Westport, I believe they show where they would actually do a turn lane there. So they're reaching down, they just did an update.
That's Westport, right?
Right.
But
And
not-
so that would mean that they're probably, that Lakeside Glen is not putting a turn lane there. So I don't think that warrants the, well, I don't want to say it doesn't warrant the turn lane. I don't think that they put enough to make the warrant for the right turn lane.
All right, any other questions for staff?
No, sir.
Do we have a motion?
No, we don't.
Well, I'll make a motion to approve to get the discussion started.
I'll second that.
Hold on for a second, unless you want to put any conditions on it.
Oh, yeah.
Because we've already indicated 2 conditions that staff recommended for the number of tents and RVs, right?
I do. I need to amend my motion. So, and what was this? I got.
Well, 18 campsites and 34 RV.
So I make a motion to approve the special exception with the limitation of 34 RV sites and 18 tent sites.
And I revise my second to reflect his amendment.
Any conditions regarding security or anything?
Well,
No.
We'll discuss it.
I mean, that gets us into discussion and I can amend my
Again,
motion.
if he has to.
You know, my assumption is, and you know what that does for you, but is that it'll operate like most state parks, that it'll have a locked gate, and if you're a registered camper, you have the code where you can get in and out, but the general public will not have the code.
Or the big
Would be my
screwdriver and the
assumption.
hammer.
And the people that come in and fishing, they come in at 5 o'clock in the morning and leave at 9 o'clock at night?
When like I go to Lake Joe Cassidy, that state park of Comanche. I can't put my boat in when I first get there if they're not open yet.
Okay.
Now, once I've registered, even for the launch, you have to register, then I have an access code where I can get out of the lock if I fish past the 8 o'clock or 9 o'clock where they close the gates up there.
How does Ebenezer Park work?
I've not used that one. I can't answer that one. My experience has been up at Devil's Fork State Park.
Okay.
Well, they have an attendant there sometimes, but I haven't gone out there in years anymore.
Yeah.
But they had an attendant there. They would drop gates, you know, the old entrance to the old boat landing. And somebody during the day is what the reason,
Okay.
yeah.
I have to believe with more consistent use, that will help with some of that.
Yeah.
I can imagine the problems you're having out there. It's unattended, it's
Yeah.
open 24/7.
It's a trash pit. I mean, I picked up trash down Viesta a month ago, and I can't tell you how
So I
much
think the
trash.
improvements would certainly help that.
Yeah.
Well, that
I
will-
agree. I mean,
That's my 2 cents.
honestly, I'm not opposed to it. I am just concerned about the traffic. I mean, I'd rather
I
have
got you.
this there. I think it's an asset to the community than another 400 houses going in there. Believe me, it's, you know,
Well, one more thing, one more condition that he mentioned, this fellow mentioned, would it, do you think it'd be a acceptable condition to add to make Rock Hill Wire and Tin Can run service down to at least the guard shack? Or do you think the county would kick that back?
Well, I think that has to be done as part of their plan for security and communication.
Okay, I'm
Yeah.
just throwing it out there to,
Yeah.
because
Yeah.
that was a.
Infrastructure needed for those
I don't know if it's gonna
surveillance
be fiber or
cameras.
it'll be cable, but it'll be whatever.
So they don't have cable now?
Do y'all have it? Y'all have high speed internet?
I do, but I'm farther down on the peninsula, and I'm not where the gentleman is. I'm
Yeah,
actually
some
on the
don't.
peninsula. He's off the peninsula. He's closer to Lake Wiley, but just on the other side of the church.
I go back to that's a condition that they may or may not be able to meet. They have no control over Comporium.
Right. I have Comporium high speed
nice.
or fiber.
Yeah, I
optic.
was
You know,
thinking about-
Comporium is his own animal.
I was thinking about a right turn lane, but that's a condition I don't think we can put on
What's that
it.
gonna do?
Now, I was thinking about fishing tournaments.
Yeah.
Would we want to restrict that until after lights been put in? Because fishing tournaments can bring in a whole lot of people, all at one time. Whereas just normal use, you won't have 150 people coming in there with boats.
Oh, you do on the weekends in the summer.
Yeah,
It's going to be no different than a fishing tournament.
No restriction on that then, because that won't change.
it won't change.
I mean, that's
They don't
the,
have 2 tournaments on Wiley anymore, do they?
Yeah, you know, they have local tournaments and things like that, but you know, the big Bassmasters series You might determine that.
They typically use,
a
they
year
typically,
if you're lucky.
and they typically use Buster Boyd
Yeah.
because of the big parking and just, you know, it's
Yeah.
more retail and,
Yeah, but I tend to agree with this because, I mean, this is what, is this the third, maybe just the second one, park that the Duke's been trying to get,
Yeah.
you know?
Mhm.
And this looks like a good
Yeah, it's
development.
gonna be nice.
I mean, it's a
I
great
think.
location for it.
Yep.
I'm just concerned about the roads, but it looks like that's up to SCDOT and.
Well, the other one, all the people that lived on those roads were concerned about it too.
Mhm.
I'm just trying to put them in the pickle where they have to be.
Any further discussion? All right, we have a motion to approve the special exception with the two conditions of the 18 campsites and 34 RVs. Sites. All in favor, raise your right hand. Unanimous. Thank you. All right,
We have a 2
moving
minute
on,
break.
we got,
2 minute break.
2 minute break.
2 minute
2 minute
break,
break.
well, maybe more than 2 minutes. It's 8:51, we normally don't, if we go past 9, we make a motion.
sorry.
to extend it.
Did we make a motion?
No, we haven't made it yet.
Oh.
I make a motion to take a 5-minute break.
5-minute break.
Second.
All right, we will resume in 5 minutes.
That break before that was freezing me.
Back here, Rachel.
It worked you over.
Hey, again. Poor Amy, she's had to sit through all this.
I'm gonna find a way to cram something down Christy Cox's throat to make it hard on him. When Kerwood and them did this, when the ZBA was first set up, Kerwood he was laughing and he said, "Yeah, we've changed." He said, "We're gonna give the landfill fights over to the ZBA." And I was like, "Why do you keep laughing?" He said, "Because I pointed you to it last week."
Well, we got cell towers, the substations, the concrete plants, I mean, that's all,
Well, I was in one of my first things. If they get approved, they wind up in front of this board is one of the things that if it starts moving.
There you
that's
go,
what's
Mr. Derek.
bad about it. Oh, them land sale fights, man, I had 5 lawsuits against me being on the ZBA board because, they sued about it. They get crazy.
Okay, we are back, resuming our meeting. Our next case, Z19-8, and I think, is this third or fourth time? All right, staff. To have a presentation?
Yep, here she comes.
Rachel?
Hello, I'm Rachel Grothy. Okay, so this is for a modification to conditions for a previously approved special exception. The property is a 6.43 acre site located at 5800 Campbell Road in the Rural Development Zone District in York. The site currently contains one single-family residence and a barn structure that is used as a previously approved event venue. This just shows the zoning of the property and the surrounding area. So some history, there definitely is some history here with this one. So in May of 2019, the board approved with conditions a special exception for a special event center. And these 4 conditions were provided, mostly having to do with timing of getting permits and plans in. So the important thing to note here is all site and building improvements shall be completed no later than May 9th, 2020. And then again, in July of 2019, the board approved with conditions a modification to the approved special exception. And this was a time extension, and it provided an extension until December 31st, 2020.
Go back one slide, please.
I'm sorry?
Back one slide.
Yes.
So, we still looking for the top three items as well as the last one?
Yes.
None of these have been met yet.
Well, I was gonna go into that to the next slide.
Okay.
So the owner was granted site plan approval in September of 2019, and they did apply for building permits on December 1st, 2020. The plans were rejected by Building and Fire, and they provided comments to the owner. And currently, to date, the owner has not resubmitted to address those comments. So this is a copy of the site plan that was approved. And then in December of 2020, the board approved a 180-day extension. So all site and building improvements shall be completed no later than July 1, 2021. And there is a current request. The current request before y'all tonight is to extend that until July 1, 2022. I believe the owner is trying to sell the property, and the prospective buyer would like time to get things in order moving forward.
And then these last two slides are just a couple of pictures from the previous presentations that went through the site. So I'm available. This concludes my presentation, but I'm available to answer any questions that you all may have about this. I know that the owner is here, and I'm assuming you are the prospective buyer.
Are they currently operating while they're working on improvements, or?
No, I've been calling and refunding and things like that with the people that I have scheduled. No commercial operation. Like I have a cousin with a baby shower and stuff this week.
That's all I got.
I'm sorry, did you say something, John?
No, I'm good.
Okay, no, so the property that is, and Rachel, again, maybe this is a question for the applicant. Amy is selling the property. Is she just selling the event center that you're aware of, or is she selling both properties?
As far as well, she's selling the entire, the
home,
entire
and, okay, the home and the
home
event center?
and-
Gotcha, okay.
Yes.
Any further questions? Thank you. Applicant, come forward. And sorry you had to wait 3 hours, but
No, it's quite all right. Amy Jeffcoat, 5774 Campbell Road, York, South Carolina.
Yeah. Steve Size, 1416 Trespass in Clover.
Okay, so I know this is awful, y'all. I didn't want to come here again, and I was hoping July would be it. But obviously, life has turned into a little bit different. So when I came in December for the extension, I had submitted the plans, and we hadn't had anything come back yet. When I submitted the plans, and the first extension was due to the state changing the building code to the A3 structure. So when I submitted the plans in December and asked for the extension, we submitted as A3 structure, thinking that this was kind of what we've been talking to the whole time, saying this is what we were gonna do. When it was submitted, they are saying now that they are interpreting A3 structure as possibly a little differently, and it would have to be an A2 structure. So that really threw a wrench for my family, my husband and I. So for example, a difference between like an A3 versus an A2 structure, for example, would be a sprinkler system would need to be added. Just a lot more, I guess a lot more restrictions and things like that, which is fine. It's just when we kept moving forward, it was due to the talks about this A2 or the A3 structure. And that's why, like I said, we had the extension in the first place. So when it came back that the county wants us to continue as an A2 structure, not an A3 structure, my husband and I just had a talk about it, and you know, ultimately we thought it was best for our family, you know, to sell it. Sorry, I put a lot of heart in this. So this is why I'm here now, because we are selling it. Sorry. And I'm asking for the extension to not like set them up for failure. Because you know, he's gonna have to redo the whole architectural design, to add the sprinkler system, to have electrician come in, all that kind of stuff. Anyway, I'm so sorry, this is embarrassing.
Okay.
So he just needs the time to get it all done, and we probably won't be able to close until June, so he won't even be able to continue working forward until it's closed, obviously. So that is where we're at. Ridiculous.
Could I pass these out? These are just, like these things.
Thank you, sir.
That's a question.
Thank you.
So Amy pretty much said most of it all. It's just, I've decided to put it in writing just so we have a quick summary of what we intend to do. The reason for the extension is she's decided to sell it. I've decided to purchase it with my wife. My wife, it's one of her dreams to have a wedding business. We watched my brother with his farm up north, and they're getting set up to do that. So she's always wanted to do the same. And the July 1st cutoff date would, of course, not just be enough time to do it. So we're asking for an extension because there's really quite a bit to do. We agree with the county's assessment, with staff's assessment, that it should be an A2. So when I went through my due diligence, I agree that that's what it needs to be, which does require extensive changes to the architectural design and a lot more money to be spent on it. So our plan of action would be, first of all, just get the ownership transferred. That could probably close sometime in June, maybe July if we're delayed because of financing. And then we would form new corporations, to operate the site in a business entity. And then part of that work will also be in parallel to create new plans and pick up where Amy left off. We'd resubmit plans as an A2 occupancy and work with building and fire officials to make sure everything is approved before we get contracts bid out for work to be done. And then now with really I'm a little worried about current labor shortages and the construction industry kind of being in chaos, but I want to make sure I've got enough time so that I'm not coming back here, in 6 months or so to say I need more time. So I think a year is probably okay. We intend to do all the work probably by the end of the year because, again, for us it's a business. We want to be operational as quick as possible so that we get our return on investment. But in case we can't finish it this year, we'd need until the middle of next year to get going.
I have a question for staff. So when we approved this special exception, it was for Amy. So does it automatically transfer what we voted on the past 4 times? Does it automatically transfer with the new owner, or does he have to go through the whole process again? With this site plan, with all, with all the due diligence before
The special exception should transfer over with the property.
Okay. Sorry to interrupt you. I just wanted to make that clear.
Is that primarily due to the fact that he is continuing with the original plan?
Yes, that's correct. So any substantial changes or modifications to what was initially approved would require hearing in front of y'all again. But if he's keeping in line with what was initially approved, then it carries over and he doesn't need to come back.
Okay.
Any further questions?
So mainly, are you looking at event centers, weddings, birthday parties, corporate, anything out of the ordinary, or?
I mean, the specialty is weddings.
Okay.
But yeah, if we can't fill it with weddings, it could be banquets, it could be barbecues, whatever.
Okay.
All right, thank you.
Thank you.
Seeing nobody else in the room? Anybody to speak against before? Public hearing is closed. We have a motion.
Motion approved.
Second.
We have a motion to approve the extension to be July 1, 2022. Okay. And a second. Any further discussion? No. All in favor of the motion, raise your right hand. Right. Thank you very much.
I make a motion to adjourn.
I'll second it.
So are you?
All in favor, raise your hand, adjourn.
Are you staying local? Okay. Good luck.